All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Salem within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, everyone. My name is Amy Blake, and I am pleased today to be joined on the bench with Justice Gregory Massing to my right, your left, and Justice Joseph Ditkoff to my left and your right. We are your panel for today's special sitting in Salem. We will get the cases called in a moment, but some words are in order. First, I would like to thank Judge Tom Drexler, if you could stand, Judge Drexler, the Regional Administrative Judge in the Salem Superior Court, who has been incredible in making this day possible. Thank you very much, Judge Drexler. And of course, Clerk Tom Driscoll, assisted by his amazing staff, in particular Carlotta Patton and Jose Mejia, if you would briefly stand. Thank you so much for allowing us to use this beautiful courtroom and for making alterations to accommodate us. Hopefully we won't lose Judge Ditkoff on the ramp today. A lot goes into planning a remote sitting, and there are so many others to thank. I wish I could name them all, but I'm sure I will leave somebody out. But in addition to Judge Drexler and his staff, Clerk Driscoll and his staff, members of the facilities and IT departments have been instrumental and frankly critical in making today happen. In fact, this will be the first time that the appeals court is live streaming an oral argument on our YouTube channel. So in many ways, you are all part of our great experiment. I'd also like to extend a special thank you to the Essex County Bar Association President Mike Merriam. I also know that I see Vice President Glenn as well as Attorney Dutcher in the courtroom. Thank you for being here. And of course, Executive Director Pam Surratt, who put all of this in place, and we will certainly have a lot more to say about that at lunch. We also have some special guests today joining us. I'm thrilled to introduce to you Representative Paul Tucker and Governor's Counselor Eileen Duff. The good news is I think Judge Duff voted for all three of us, so there shouldn't be any conflicts today.
You voted me to judge just then.
The Honorable Governor's Counselor Eileen Duff. Thank you. And I'm sure there's plenty of you that are watching online, and we thank you and really are thrilled to be here. Now to our business. Today we are scheduled to hear 6 cases. The first 3 will be criminal. The last 3 will be civil. We will take a brief morning recess after the 3rd case. The cases are going to be called one out of order from what you may have received in your packet, but we will hear all 6 today. During the break, for those of you that might be live streaming, the video and audio will be muted, but you don't need to sign off during that brief break. In terms of our rules, each side is permitted 15 minutes of oral argument. There is no rebuttal. In some cases, lawyers will be splitting their time, and the clock will reflect that. We will ask, consistent with the mask policies in Salem, that everyone in the courtroom keep their masks on. When it is your turn to present your case, you may remove your mask, but in so doing, you are representing to us that you are fully vaccinated. You are welcome to keep your masks on if you prefer. The 3 judges have conferred, and we have decided to not wear our masks today, but I have their permission to report that we are all fully vaccinated. Some of us even have the booster. Our court officers today joining us from the appeals court are our Chief, Dana Smith, and Ron Spady, and we're pleased to also have from the Superior Court, Tamiko, joining us today. They will wipe down the podium in between each speaker out of an abundance of caution. With that said, I think we are ready to call our first case. And so we will begin with Commonwealth versus Courtney D. Gardner, docket number 2019 P1833. And counsel, we appreciate that you have to get right to Middlesex after your argument. So please, when you're ready.
Please, the court. I begin with the first issue in my brief. This is a case where there was a video that was played in front of the jury. It was authenticated by the witness. The witness testified, answered the following question, yes, sir. This video, apart from being daytime as opposed to nighttime, is it a fair and accurate representation of the path that Ms. Gardner's vehicle followed?
So let me stop you if I could. When I read your brief, I was with you all the way until we got to the point where the jury actually saw the entire video, and in fact, trial counsel was able to pause the video, cross-examine the officer about what was seen on the video. So as I understand it, the only thing that didn't happen was that the video itself was marked as an exhibit and admitted as an exhibit. So what difference would that have made in view of what I've just described?
Well, in light of the jury instructions, so in particular, the motion to admit the video was made as an exhibit was made in front of the jury. The case was called the sidebar. It was marked for identification. It was never presented to the jury. And in his closing instructions, or in the jury instructions, Judge Galey instructed the court in particular, don't consider any item that was marked for identification but was never received into evidence as an exhibit. And that's
Did he tell them not to consider what they saw on the video or the cross-examination about what they saw on the video?
He did not specifically tell them anything about the video during those instructions, but that was the only piece of evidence that was requested to be marked as an exhibit and was not marked as an exhibit. And certainly the jury can't have failed to notice that it was moved in as an exhibit, it was never entered in as an exhibit, and it wasn't brought back to them in the jury room for them to have access to. So any juror paying attention to that charge, not to consider any item that was marked for identification but was not received into evidence, would very reasonably have understood that they were not to consider what they had seen on that video, because that's explicitly what the instruction tells them to do.
So you were trial counsel, right?
Correct.
And you did not object to the instruction?
Well, it was a correct instruction as a matter of law at that point. The evidence had been incorrectly excluded as evidence, but the judge did instruct the jury not to consider evidence that had been marked for identification and not marked as an exhibit. So that instruction wasn't...
You could have asked, Judge, consistent with all you said during the trial, couldn't you tell the jurors that they consider it for impeachment purposes?
It's true that there could have been a further requested instruction at that point, but I think the damage was done at the time that the evidence itself was excluded. And that instruction, it's not just that that instruction was the only prejudice, but that instruction did make the prejudice worse. So we're not talking about an instruction that in and of itself created error, but an instruction that just simply made the prejudice worse from an error that had already occurred.
So you say that by excluding that evidence and by that instruction, the judge infringed on your client's right to present a defense. What defense were you not able to present?
So what was in contest during this trial was the quality of the driving in comparison to the roadway, and also the physical observations of Ms. Gardner's appearance and driving. So what I mean by that is the Commonwealth in their brief argues that there was overwhelming evidence in this case, but essentially cites only to the testimony of the police officer. So what was in dispute is that the independent witness who had been a passenger in the car testified that Ms. Gardner was not slurring her words, was not unsteady on her feet.
The question I asked you was, what defense were you not able to present? You're telling me all the parts that you were able to present.
Yes, I'm sorry, I'm getting to that. My point is that in particular, this video demonstrates the poor quality of the markings on the roadway, which was one of the main bases for the officer's stop. And in fact,
the officer admitted on cross that it wasn't marked at that point. There's a point where he said, and you say, so she was just driving in the middle of the road. And that's in evidence, right? And the jurors didn't have to ignore that.
That question and answer, correct. But the other thing that, and I guess I would urge Your Honors to, I'm not sure whether the identifications have been transmitted to Your Honors or not.
We have them.
But as the video progresses, you can see a number of stoplights that are gone through, and the officer simply testifies, well, she was speeding up and slowing down, not in relation to those stoplights, but really apart from the video, the jury doesn't have any sense of when the defendant may have to slow down in lieu of traffic or a stoplight and things like that. And so it gives the jury a legitimate way to judge how one who is not under the influence would be able to drive that stretch of roadway, the things that one would have to react to in terms of roadway obstacles, as I said, intersections, stoplights, things like that. And it deprived the jury essentially of what they would have been able to do had they been given a view or something to that effect.
Obstacles on the video. I mean, there are, of course, traffic lights, and you can see the roadway pretty well. But I didn't see any obstacles. Did I miss it? I watched the video twice.
I guess by obstacles, I really meant intersections. So no, there's not barriers in the roadway or something like that, but we're talking about there's a number of intersecting roads, but in addition to intersecting roads, there are a number of intersecting driveways to businesses and things like that. And all of those things, the jury would have been able to use their view of those aspects of this roadway in their assessment of whether the testimony and other evidence as to Ms. Gardner's driving made sense and was accurate. So it really was a crucial piece of evidence because otherwise it's just the officer's word as to the condition of this roadway. And I realize he did testify that the markings were not great, but this was really an objective piece of evidence that the jury could have used to assess. And again, it's not just the condition of the roadway, but also the path that the vehicles traveled and how it is that somebody who was not under the influence would have had to approach that section of the roadway. And again, I just wanted to briefly return it. Again, this is not as to the evidence that was on there, but as to the prejudice. I just want to return. The Commonwealth again suggested that the evidence was overwhelming, but that's just not so, because when we compare the officer's testimony to Mr. Sears, the witness, again, not slurring, according to Mr. Sears, not unsteady on her feet, did not smell of booze, did not have bloodshot eyes, and the driving was fine, quote, up until the end. And we see that in the transcript at page 78. So
At any point did the jury ask during the deliberations to see the video?
No, Your Honor.
Do you want to move to your juror issue?
Yes. With regard to the colloquy itself with the jurors, I point, Your Honors, to page 31 to 35 of the transcript of that first day of trial, which is named as T2 in my brief, but it's the first day of trial. I think that I leave that to Your Honors to determine whether that demonstrates a lack of English proficiency or not.
You certainly aren't arguing that a juror must speak perfect English, right?
Correct.
And I think in isolation, your argument has some force, but then when you read the entire colloquy, up through the judge asking for the third time about her ability to hear the case, she ends by saying she could definitely be fair, and there was nothing about her responses, at least that I saw, that said she didn't have a significant misunderstanding. So what's your best case, I guess, on this issue?
I'm not sure that there is a case directly on point. The Commonwealth cites a couple of cases in their brief. I think one of them is CM, and I can't remember the name.
Haywood?
The other. That may be. But those cases involve Commonwealth peremptory challenges to witnesses that are deemed to have been upheld, as opposed to cases where a juror has been challenged for cause by the appealing party, which is really the case here. But I think that those cases nonetheless do provide some instruction. a juror who has difficulty understanding English obviously is going to have difficulty understanding the evidence because all of the evidence has been given in English. And I would suggest that, yes, some of the questions she gives responses that are proper to, but for the most part, those are yes or no questions, not exclusively. I think the answer that she has that's responsive, that's the longest in terms of a sentence, is I think something along the lines of "I don't believe so," when she's asked about whether she has family members that are in Mothers Against Drunk Driving and things like that.
The one when the judge says, you speak pretty strong English. Do you feel comfortable having a proceeding, an important proceeding in English? And she says, I feel comfortable. I've been here 20 years and I work for a company and I travel a lot. I communicate with a lot of people. That's a pretty good answer.
It certainly is an answer. I think that I'm not sure that that's the exact wording. I don't have it directly in front of me right now, but again, that's probably one of her better answers.
She's been in the country 20 years and she uses English for her work.
I would just point out that when one considers some of the other answers that she gives, they simply don't, they're totally unresponsive to the question that has been asked. And
can I ask you about the prejudice?
Yes.
You actually did have an opportunity to use a peremptory against her. You chose that when she was seated, there were others who obviously you thought would have been worse for your client, so you struck them instead, but you could have struck them.
So here's where I think that analysis is incorrect. So the Commonwealth cites to Nelson. In Nelson, the peremptory challenges were exhausted on jurors that had not been challenged for cause. There were 2 peremptories available in this case. Each of those peremptory challenges were exercised on other jurors that had also been challenged for cause for whatever reason, for independent reasons. So
you exercised those after juror 12 was seated and your request to strike for cause was denied, right?
That's correct, but my request to cause had been denied as to each of the 3 jurors at the time I exercised the peremptory challenge. So essentially,
how many peremptories did you have when juror 12 was seated?
I believe the answer to that is 2. And so what happens, as I recall, and Your Honors can review the transcript, as I recall, that either 7 or 8 were seated first, and then the judge began the process of peremptory challenges. So all of the peremptories would have been in both parties at the time of the first challenge for cause. But essentially what the Commonwealth's arguing when it says that there's no prejudice here is if you've challenged 3 jurors for cause and you use 2 of your peremptory on 2 of those jurors, you're without any recourse as to the 3rd, and that can't possibly be correct because otherwise, if I had used the peremptory on this juror, I would have no ability to raise on appeal the challenge for cause to one of the other jurors, and that.
I thought you passed on this juror keeping a peremptory and then used that peremptory later on a juror that was added later. Isn't that right?
I believe that this juror was in the original seating of the panel and peremptories were not available yet.
You used one with 2 peremptories. In the first panel, you used one. You passed on this juror keeping a peremptory in your pocket to be used later, which you did use later, but to be used later. Is that correct?
I don't believe that peremptory challenges were open as to, in other words, these were not done in real time. It wasn't challenge for cause, challenge for peremptory. It was seat a panel, challenge for cause.
There's a panel set.
Correct.
And you use a peremptory on one of the jurors, letting this juror sit, and you're done with this panel of 7 holding a peremptory in your pocket that you then use later when a juror gets added, correct?
Oh, I see what Your Honor is saying. I believe so the first peremptory challenge was to another juror on this same panel with this juror. And then the next juror was seated in that seat, but the judge wasn't inviting 2 peremptories at once. It was each party exercises a peremptory, the seat is filled, each party exercises a peremptory, the seat is filled. So there wasn't a point where Ms. Gardner ever gave up her right to peremptory challenge this witness or passed on a peremptory challenge of this witness. Again, both of those peremptory challenges were used as to jurors seated on that same panel that had been challenged for cause.
I see your time is up. Let me just check with the panel to see if they have any additional questions.
Thank you.
Seeing none, thank you very much. And please, on your return after council presents, thank Judge Kazanjian for us. Thank you, Mrs. Beatty. Ms. Johnson, when you're ready.
May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex on behalf of the Commonwealth. And I'd like to start with the jury issue since we've already, we talked about that last. And I'd like to point out first, this is particularly the type of situation where a trial judge is in the best position to evaluate whether someone is qualified for service here. All those facial expressions, the hesitations, all of those things that are not reflected in the transcript, Justice Galey, was able to perceive that juror, that prospective juror, and determine whether she was qualified. And here, as you point out, Justice Blake, he acknowledged that her English was pretty strong, and she responded that she had been here for 20 years. She communicates with a lot of people at work. And really, it's interesting because she had no problem with the complex questions he was asking about the standard of proof and the burden of proof and beyond a reasonable doubt, and whether her family was involved in OUI matters. All of those were easy for her, and she was able to answer those questions. And in truth, I think Justice Galey admitted maybe my questions about her views on alcohol were probably not as artfully worded as they could have been. In the end, she did acknowledge, and she said that her experiences would not affect her ability to be impartial. So for those reasons, I don't believe the defendant has made out the case that this judge abused his discretion in including this juror in the panel. Is there any further questions?
I ask about Attorney Faulkner's point, is that he exercised, you say that he didn't preserve it, or there's no prejudice because he could have challenged, and perhaps he could have, but the fact was he used his only two peremptories to challenge jurors who he had challenged for cause.
True.
Doesn't that sort of make it a different analysis?
It's a tricky question, Your Honor, and certainly I think that our strongest argument is the abuse of discretion. I always hesitate with the peremptory challenge issue, but the fact remains is that he had two peremptories that he had not used at the time that this juror was up for challenge. Never used, bypassed this juror, and as Your Honor, Justice Ditkoff had pointed out, the panel had been reconstituted to the point where he ended up using those peremptories. So if you look at if you look at the entire jury selection process here, and whether he really was deprived of that challenge, I don't think that that's true here, Your Honor, given the fact that the panel was reconstituted and he then exercised his challenge on a newly reconstituted panel. So I think in that case, I don't think he could make out a case for prejudice. I acknowledge that it is a tricky issue. There's only 6 jurors, and there's only 2 peremptories. But in this case, it couldn't have been so much of an issue that he didn't immediately strike that juror as soon as she was up for challenge. I think that really goes to the fact that perhaps her English was much better than this defense attorney makes it out to be.
Could I ask you about the video?
Absolutely, Your Honor.
Why doesn't it go to weight and not admissibility?
That's an interesting question as far as the authentication issue. I do think in this case, with a video, the judge does have discretion to figure out, does this really accurately reflect what happened at that time? And that's
well, certainly we don't have a video at the time.
Right.
My guess is you wouldn't be here if we did.
Right.
So if the officer is able to authenticate that that's a fair and accurate representation of what that road looks like on the month and time that it was shot, then I guess isn't it a question of weight? wouldn't the government just argue, look, these weren't the same conditions?
I think we could have been, and it was within Justice Galey's discretion to have admitted it in that form, but for him, he really felt that the ability to see those markings was a huge difference at night versus during the day, to the point where
But there were no markings.
it's not.
The markings that would have been visible at any time.
Well, I think that the entire video was showing markings at different points and whether they were rubbed off or not, and that was the defendant's argument. And I think it was within his discretion to say, you know, a photo or a video is only as good as the time that it is taken in terms of whether it accurately reflects what happened at the time. And here, that was a critical issue. And so it was within his discretion to say, you know, this is not an accurate reflection of what she had perceived at the time, and that's really the whole issue here. But I agree with you, it would have also been within his discretion to have allowed it and allowed it to go on to the jury. At the end of the day, there's really no prejudice here because the jury saw the video, and the defense attorney was able to pause it and ask the officer questions, and the officer answered those questions and even admitted that the markings were pretty rubbed off at the time. But this is kind of a case like that Zengalowski case that I had cited. Granted, it's an unpublished decision, but it's really talking about, in that case, it was like melted snow or snow tracks, which were taken 3 days after the event. So you can see in that situation that timing really can be critical with a photo or a video. So yes, I do think in this case there is a discretionary call for authentication, but it could have gone to Wayne had the judge so decided. But no prejudice here, able to play the video. And I think the question is, could the defense attorney really use this in support of the theory of defense here? And this defense attorney absolutely was able to use that video in support of the theory of defense, that those markings were so deteriorated, rubbed off, that she really couldn't see. And that's really what the question at the end of the day is here, is that this defendant cannot prove prejudice from what the judge did here. If there are any further questions, I will rest on my brief.
Thank you very much, counsel. Thank you both for great presentations. The matter is under advisement.
Thank you.
No speeding tickets on the way to Woburn. Chief, could I see you for a quick sec? Okay, the next case, if counsel wants to set up, is Commonwealth versus YORDALI YORRO, docket number 20P1297. Everything okay? Mr. Carter, everything okay? With
Nothing.
You're not calling.
Okay, good. Yeah, I don't need it. No, but if you don't want too much.
Here, everything good? Good morning, counsel. When you're ready.
Good morning. Justin Cohen.
Could I ask you to be much louder?
All right, Justin Cohen for YORDALI YORRO.
Thank you.
The two major issues in this case are that the pass was unconstitutional and the motion to suppress should have been allowed. As this court knows, for the police to do a pass arrest, they have to show that a person is violating the law and that same person is presently armed and dangerous.
Let's start with the first piece, right? So the Commonwealth's argument then and now is that your client was committing a trespass.
He was not charged with trespass.
True.
And really, anybody on a sidewalk, when they're not actually, but police were doing freedom of information requests and people were free to leave.
Was your client on the sidewalk when the officers spotted him, or was he on the property of the housing project?
He was on the sidewalk.
Didn't one of the officers testify that they moved them off the property onto the sidewalk? And does that matter?
I believe the testimony was that they were on the sidewalk, or Mr. YORRO was not charged with trespass. He didn't make any threats, and he didn't do anything illegal. They were doing freedom of information request.
I want to just push back a little bit, though, on this question. Can a person trespass on a public sidewalk?
If they're not asked to leave by police, I don't think that doesn't comply with the trespass, and I argued that in the brief with a number of cases.
If there's no trespassing sign, why do you have to be asked to leave? It has to be posted in some way, either verbally or by signs, but why does it have to be oral?
Because ordinarily, if there's a trespass, if someone is not lawfully allowed to be in a place, or they're asked to leave. And so certainly, Mr. YORRO was not even charged with the trespass, so it's a non-issue.
Well, it is an issue, right? Because it's what the Commonwealth says is what gave the first prong of reasonable suspicion, was that he was committing a trespass.
Oh, well, he wasn't charged, and he didn't manifest any, well, first of all, he made no threats, and he was free to leave. He was walking to a nearby SUV at the time. There was no age element, so no suggestion that he wasn't of age to have a firearm. Brito said, use caution with him. He is
Hold on a second. I believe Justice Ditkoff has a question.
Detective Brito testified, when we first approached on scene, they were standing on the property, on the lawn of the property 383. And there's some reason why that couldn't be credited, that they were actually on the property instead of the sidewalk?
I think one of the other officers testified that they were on the sidewalk. And again, really armed and dangerous, that part of it, because Mr. YORRO was not charged with trespass, made no threats, he did nothing illegal. He was walking to this nearby SUV.
But let's not conflate them, right? Because we have to look at whether he was committing or about to commit a crime, and then we have to look at armed and dangerous. You're not conceding that he was committing the crime of trespass. I want to be clear on what your argument is.
No, I'm not conceding
Okay.
that because he wasn't even charged.
So does he have to be?
It's really a non-issue because he was not even charged with it.
Well, it would have been helpful if he was charged, but does our case law say he has to be charged?
It doesn't actually deal with that, but all of the trespass cases that I cited, this doesn't even comply with any of those.
Okay, on the armed and dangerous, what do we know about the timing of the video where your client lifts up his shirt, displays a firearm, and says something to the effect of, "I always have it on me"?
Yes, Brito had seen this undated video, which...
When did Brito see it? What does the record tell us?
Brito knew that he had it in March before the September 8th, 2017 patrick. And he didn't know when it was produced, and he didn't know if it was an actual firearm. And then Brito did surveillance of Mr. YORRO, and he never saw him with a firearm. And even this person of interest information is a non-charge. So Brito shouldn't have said it, but he said it. But the point is that Strong did the pat frisk of Mr. YORRO as he was walking to that nearby SUV. And Strong testified that he pat frisked him because he might potentially have a firearm. That is not armed and dangerous. That is not the standard for police to do a pat frisk. So that was an unconstitutional pat frisk.
What about officer safety?
They all agreed that nobody was violating the law except that trespass issue.
What do you need beyond might have a firearm have reasonable suspicion that someone's armed?
I think the best cases to look for this is other cases. This is not Terry v. Ohio, involving 3 people returning 24 times to stare at a jewelry store window and mumbling about identification. This is not Fisher involving a quick move to the waist area. This is not Mana involving displaying or pointing a firearm. This is not Karen K involving kids who are displaying a firearm. This is just him walking to a nearby SUV, and the testimony was that he got up, he was right there, and the door was open for him. But Strong blocked him from going into that nearby SUV.
Well, just prior to that, though, right, hadn't they asked all of the individuals to sit down? And as I think I remember the transcript, your client did briefly and then got up and headed towards the car, which the motion judge found, I think he used the word noteworthy.
Yes, the judge did say that. And I will.
So what do we do with that?
Well, that is neither illegal nor suspicious. This is not.
Isn't it part of the totality of the circumstances?
To sit down and walk to a nearby SUV?
In these facts, with the gang task force conducting impact patrols in an area with the reports of violence and gun violence and youth congregating?
In Cordero, this court, the SJC has urged caution with using a high crime area as a consideration.
I completely agree with you, but that's not my question. If we look at the totality of the circumstances, your client's movements, the judge found to be noteworthy. Are you suggesting that that's clearly erroneous? Because
yes.
we're required to adopt his findings unless they are clearly erroneous.
All right.
So what's clearly erroneous about that?
Well, he did get up, but it's certainly not noteworthy that he got up to walk to a nearby SUV. And that was in the officer testimony.
All right, let me add another fact for you in my totality of the circumstances. Brito knows that your client is a suspect in an unsolved homicide. How does that affect the totality of the circumstances?
Because firstly, it was a non-charge, and Strong was the one who did the pat frisk, and Strong testified why he did the pat frisk, because he might potentially have a firearm. He never
So that he was a suspect in an unsolved homicide is irrelevant?
It's not what Brito said, it's what Strong testified.
Well, no, I mean, the police they can have collective knowledge, right? I mean, we can attribute Brito's knowledge to Strong.
But yes, but that's not the case, because Strong did not know about the video.
I think he doesn't have to know. It's the collective knowledge doctrine. We can attribute the knowledge that he doesn't have.
But yes, but they specifically testified, Strong specifically testified that he didn't know what Brito knew. So it's not that they all knew the same thing. Strong hadn't seen the video. Strong did the pat frisk and blocked Mr. YORRO from walking to that nearby SUV.
Okay, but at transcript 1, pages 14 and 15, Brito told Lopez and Strong to, quote, use caution with Mr. YORRO because, quote, he potentially might have a firearm. So when Strong approached him, that's the information he had. We don't have to guess. That's the information he had.
But Strong testified why he did that, might potentially have a firearm. Nothing that Mr. YORRO did was illegal. Just walking to a nearby SUV and making no threats, doing nothing illegal.
I don't understand. If he reasonably suspects that the defendant has a firearm, isn't that enough to pat frisk him?
That is not enough, because you need to show that the person is presently armed and dangerous. There are no threats, there's no age element, so there's no suggestion that this firearm was illegal.
I agree that the standard is not armed, it's armed and dangerous. Are there cases that distinguish between the two?
Yes, actually, in Terry v. Ohio, the standard is if the officer believes that the person has a firearm and intends to use it. And that's also in Massachusetts, in Martin, the same standard. And there's no way that Strong reasonably believed that Mr. YORRO had a firearm and intended to use it.
Can I ask you about the pat frisk? Do you agree with the Commonwealth that you've raised the plain field doctrine for the first time on appeal?
I think that, yeah, the plain field doctrine, I believe the standard is, yeah, I believe it is the first time on appeal. And that goes to the way, first of all, it was an unconstitutional pat frisk, but the way that Strong did the pat frisk rendered it further illegal.
By moving the pocket?
By using a flashlight. And, yeah, and the firearm that we found on Mr. YORRO was inside of Mr. YORRO's sweatshirt. So it's not like, again, there's no suggestion that this firearm was illegal, and he was doing nothing illegal. Just walking to a nearby SUV is not illegal, even if you're asked to sit down by police and they're doing freedom, they're doing FIOs and everyone is free to leave.
It's field investigation. I forget what that acronym is, but it's like field investigation. Like it's not freedom of information, it's field investigation. But
right. Yes. I'm sorry. Yes. That is, yes, that is what they did, and he was free to leave. So the motion to suppress should have been allowed. It was denied, but it should have been allowed. The motion asserted the Fourth Amendment and the 12th, 13th, and 14th articles of the Massachusetts Declaration of Rights. So this is a preserved issue. And firstly, the motion judge stated that it doesn't take much to move the needle in terms of officer safety. There were 6 to 7 officers. 3 of them testified. None of them testified about safety concerns because there weren't any. And then the motion judge also talked about what Brito noted to Strong as justifying a brief pat frisk. And I already talked about that Strong didn't know, but Strong testified why he did the pat frisk. And so I see that my time is almost up. So if there are no further questions.
I see no further questions, Counsel. Thank you. We'll take the rest of your arguments on your brief. Thank you.
Thank you.
Thank you, Mr. Spady. Attorney Sullivan, good morning.
Good morning. May it please the court, Catherine Sullivan for the Commonwealth. Welcome to Essex County on behalf of the DA's office here. For some of you, welcome back to Essex County. As I stated in my brief, there is more than reasonable suspicion to warrant the officer's stop and subsequent pat and frisk of the defendant here. The judge's findings were thorough and they should be relied on by this court in upholding the denial of the motion to suppress.
so let's start with the thorough findings. When did the stop occur?
Right. So would it have been better if he had explicitly talked about that in his findings? For sure. I think.
So when do you say the stop occurred?
So I think the stop arguably could have occurred when the officers asked the group to move from the lawn onto the curb and sit down. There was a change in addressing the group from when Detective Lopez initially said, "Hey, you guys, what's up? Who lives here?" And then at some point,
So are they free to go at that moment?
I'm not sure that if they would have felt free to go, based on the number of police officers there relative to the number of, you know, people in their group, but I think probably they would not have been free to leave once they asked them to sit down on the curb. But at that point, they certainly had reasonable suspicion, if not probable cause, that at least one of them, at least the defendant, was criminally trespassing.
Well, let's explore that. He's on the lawn. They know that back in March, he didn't live there.
Correct.
But one, how do they know he doesn't live there now? And even if he doesn't live there now, how do they know he hasn't been invited by someone who does live there?
They don't necessarily know the complete answers.
How they suspect it, I should.
Well, Detective Brito had specific evidence that he lived in Lowell at that point, and I think he testified that he didn't have any information that he had changed addresses. So he reasonably believed at that point that the defendant was not from that area. So in light of the complaints from neighbors that said there were groups hanging out that didn't belong there, in light of the signs posted, they said there were numerous signs around, and in light of Detective Brito's information about where the defendant lived, at least there was reasonable suspicion to conduct an inquiry to determine if they in fact lived there or if they were criminally trespassed.
So the most recent information that Brito has about the defendant is a video he received on March 27th.
Yeah, it's a little bit confusing in the record because there was evidence of bulletins that came in to the Lawrence Police Department, and some of them, though not all of them were dated that week, and there was some discussion about when exactly they were dated. The defendant did appear on those bulletins, but for the purposes of the testimony, specifically of Detective Brito, I think his information relates to the grand jury investigation in March and what he knew about the defendant then, coupled with the video. So he had both the homicide investigation, where the defendant was a person of interest, and the homicide specifically involved a firearm, as the judge asked. And then he also had the video from around that, or that he received around that date.
There's a case that we wrote in 2019, Commonwealth versus Hart, where we said a search warrant was invalid or relied on information that there was a gun in the house 2 months before. And we said information that there was a gun in the house 2 months before is not good enough to establish probable cause, but there's still one now. So here we have a video from 6 months before.
Right.
How much can they really rely on that to establish that he's actually armed? And we'll just get to dangers next, but at this moment in time. So
the case law is pretty clear that it's all about the officer's reasonable belief, right? And I don't believe, in terms of informing reasonable suspicion, I'm not sure that there's a limit, a time limit on that, if it's within reason. And, well, certainly, I'd say, one, the defendant didn't raise that issue. Two, I haven't addressed Hart in my briefs, and I'm just sort of winging it here a little bit, but I know the case law does rely on the officer's reasonable belief. Was it reasonable for him to believe that based on that video, the defendant would be armed? Well, you have the defendant saying flat out and showing a picture of the firearm in his belt, "I always have it with me." So if I'm an officer and I see that video, I think it's reasonable to assume that that defendant is going to be armed going forward. So is that reasonable? Yes. And I think, and I cite Cullen in my brief too, that there are different stages and different circumstances in the analysis, including, for example, the defendant's demeanor and his behavior in terms of getting up and walking away. And while that might, in certain circumstances, might be ambiguous, the risk of that ambiguity doesn't impinge on the officer's determination of reasonableness or his anticipation or his behavior in light of that circumstance. If he is reasonably in fear or thinks that the public is in danger or believes that the defendant is armed and dangerous, if that belief is reasonable, then I think that gets us as far as we need to go. And in here, based on the totality of the circumstances, I think we had several factors that led them to believe that there was reasonable suspicion that he was armed and dangerous. And
Can I back you up to trespass for a minute?
Sure.
The judge credited the testimony of all three officers, but they were inconsistent in their testimony about where Mr. YORRO was, right?
Right.
One, I think it was Brito, stated that he saw a number of individuals on the property when they arrived on the scene. I'm not trying to surprise you, but in thinking about this issue, I found an old case from 1997. It's called Walker versus Georgetown Housing Authority, where the SJC said streets and sidewalks of a development used as access to the entrances to the apartments fall within the classification of a public forum. If that is true, can you trespass on them?
I'm not sure.
Me either, that's why I'm asking.
Arguably, yes. Why not? If there are...
Because there's a no trespassing
Right,
sign?
exactly,
Okay.
exactly. If there's a sign that says, you know, residents only, or maybe, I don't know what the sign says now, and I don't think a picture of the sign was admitted, but I'm not positive. I know the officers testified to multiple signs there, and the judge found that there were signs. I'm not sure what the case would be if there were restrictions, for example, on those signs, residents only, 9 to 5.
There is at record 19, there is a photo. No trespassing, no loitering, police take notice, 383 Chestnut.
Right. And I know that the loitering calls and the neighborhood complaints were a primary reason for those impact patrols, and the designation of that area as a hotspot. So it's not a question without, you know, some importance.
And you would agree that Mr. YORRO didn't have to be charged with trespassing? It
Certainly.
perhaps would have been easier if he had been, right?
Certainly, there's always going to be an easier scenario. Also, to Justice Ditkoff's question, I'm not sure that if there is a distinction between armed and dangerous. Again, I mean,
they say, it was me, actually.
Okay, sorry.
Armed and dangerous, and so if you say, well, he's armed, that was the and dangerous part.
Right, and you know, certainly like in Karen K, you know, in other cases, we talk about the behavior of the defendant and whether it was, you know, sort of obviously dangerous, you know, in the circumstances and leading up to the stop or leading up to the pat frisk. And, you know, certainly someone just getting up from the curb and walking isn't a dangerous act per se, but when there's a reasonable belief and there's evidence that he's likely armed and he's moving towards a nearby car that has an open door and someone driving, you know, that changes the calculus a bit.
You know, the seems to be the most reasonable because he's trying to get away.
Right.
So which I mean, is that a threat? If he's trying to leave, is that a threat to the officers?
Well, it's a threat to public safety, and you don't need a direct threat to the officers, or we just need, you know, dangers to the public.
I think it's dangerous if the police, I mean, does it have to be that the person would be dangerous if the police do their inquiry? Or is it just dangerous if they let him go and don't do anything? We don't know.
It's like a catch-22, right?
In the feeling.
Yeah. I'm just going to go back to the reasonableness of the officer's belief that the defendant is dangerous and assume that the officer's conduct doesn't create the danger, that the defendant's behavior is the danger.
Do you want to skip to the frisk and your brother's argument about the use of the flashlight and the officer's finger to manipulate the pocket?
Right. So I think that the case law is pretty clear, and I cite Narcisse and Cullen, that an officer is entitled to do what's minimally necessary to ascertain whether the object is in fact a weapon. And here, there was a little bit of conflicting testimony from Trooper Strong. I mean, at one point, he said he saw it through the sweatshirt, and then he says, I used my flashlight and I opened up the flap and saw it. It was, all the officers testified that it was nighttime, it was dark. So take that testimony as it is, but I'm not sure if there was an outline of a gun there. But in any event, I think he did do what was minimally necessary to ascertain if it was a weapon by sort of inspecting further. If he could see, he verified that. If he could see an outline or see what he thought was a gun, he sort of verified that further by shining the flashlight in and, you know, frisking him and then retrieving it.
Did he see the outline of the gun before he stopped and frisked him?
No, he stopped him. He said he saw a gun. He stopped after he stopped him. Yep. So to the extent that tries to clear it up. With regard to my brother's second issue, I think, except for the fact that the defendant was an African-American man, I'm not sure what nationality or ethnicity he was. He has dark skin in the video. There is no evidence whatsoever that race played a role in this episode, in these circumstances, and it's distinguishable from Warren across many features. Most importantly, that Detective Brito recognized the defendant immediately and warned the other officers about him. In Warren, they were looking for a suspect in a shooting. They didn't know who it was, and they were told that he was a black man, had dark skin. The other big difference here is that at trial, because this goes to the defendant's claim of insufficiency or the conviction itself, there was a bench trial, and we can assume that the judge instructed himself correctly on the law in this case. There are no other questions.
I see none. Thank you. We'll take the rest of the argument on the brief. Counsel, thank you both very much. The case is under advisement. Thank you, Chief. All right, our next case is Commonwealth versus John T. Lewis Jr., docket number 19P1837. Attorney Hagar, when you're ready.
Yes, good morning. May it please the court, Mr. Hagar for Mr. Lewis. Mr. Lewis is on appeal. I'll get the first issue to deal with the issue. We're dealing with abuse of discretion. And although the judge has a great deal of discretion, he may not use in such a manner to deprive the defendant of constitutional rights. Assistant counsel, Ditkoff, and most specifically, he used an opportunity to defend himself, to defend.
Counsel, I assume you've seen the 16L letter submitted by your brother.
Yes.
About the case that was argued a couple months ago at the SJC that deals with a very similar issue about the expectation of privacy in a Snapchat video.
Okay.
Have you seen that?
Yes, I saw that. I can jump it out
Okay.
if you want. I can do that now if you want.
Do you think it would be prudent for us, we're certainly going to hear argument this morning, but to stay this case pending the results of Carrasquillo?
Possibly, yes. Yeah, I would do that, yes. The SEC case. My quick point on the issue, I read the Cook case, Your Honor, and my thought is, the fact that normally a text, an email, and a mailing, you distribute something, you kind of lose your rights. But a text, a mail, an email, you actually give it away. It's like a permanent. To me, Snapchat is different about the 24-hour up and it's down again. So I think that changes things. And I also think quickly, one second on this, is the fact that technology changes and the venue, how you search people, was plain view or telescopes or smartphones or internet. It changed a lot, changed a lot. I think this technology, I think specifically with staff sitting a 24-hour up and down, they changed things. Of course, maybe access to privacy that most of them for 24 hours, I only delivered it. So that's my thoughts on that.
You said that you, I don't recall if you were counsel below, but that a request to continue was denied, but was asked because of a, what you say is a racial profiling litigation. And is it correct that that case is still not, the case that you were relying on issue number 1, that case has still not been decided, right?
No,
it's still in the trial court.
Exactly, at the trial court, exactly, Your Honor. And so the second issue, like I say, I'll rest on that. Regarding the Dilworth issue, especially what Dilworth did was it opened the door to potential defense. And if you walk in that door and you win the argument, the case is dismissed. So the Judge Locke denied Mr. Lewis an opportunity to walk into a door, join the Dilworth case, argue that.
Why didn't Mr. Lewis have an obligation to raise this earlier, just like his Roxbury defender's colleague did, in raising it in the Dilworth case?
Well, Charles may not realize it. I think she realized after co-counsel filed it on Dilworth 5 days early and Judge Altman made his ruling. But I think...
So you're saying, on the day of trial, counsel comes up with a new idea, they're entitled to a continuance, it's abuse of discretion. Because, Judge, I didn't think of it until just now, but I thought of something now. Can I have another 6 months?
Well, no, I think if something is valid, you should allow it to happen. I mean, I understand as an inertia, you want to go to trial. I understand all that. But my view is that some counsels, including myself, may not know everything. And she found out 5 days earlier. She was not aware of it, and she decided to think of it.
But you didn't need the Dilworth case to analyze this case and say, geez, I wonder if there's an expectation of privacy that's been violated in the police profiling and pretending in a ruse to be somebody to have a Snapchat friend, right? She doesn't need Dilworth to figure that out. You look at the case and you say, geez, the police set this ruse up. I'm going to file a motion to suppress because I think that my client had a reasonable expectation of privacy in his Snapchat story. Dilworth is more icing on the cake. Your sister counsel below needed to bake the cake first.
Well, I think it's 2 issues. One is the issue of the deception, and the other issue is racial profiling. I think it's separated. There's 2 grounds to push the evidence.
But isn't the racial profiling claim that the police were using a ruse to racially profile people to create fake Snapchat friends, to friend people for this exact purpose?
Well, no, one is an act of, one is an act of decepting people. Could be, that's one act. Another act is racial profiling. That's separate. 2 different decisions out of the police.
Racial profiling was to figure out who we were going to target. The claim in Dilworth is that we were using racial profiling to choose only black people, and that's on which we would then do a ruse.
Yeah, exactly. I mean, racial profiling could be in traffic stops, could be anywhere you want. I mean, racial profiling could be in drug sales and drug busts, but that's one issue. The act of saying, I'm going to racial profile somebody, and I want to get dressed and motivate all of my investigations solely on people of color, that's one issue. The other issue is use a venue to try to deceive people, so I get them to grab me and try to sting on race. So that's separated.
So what's the standard for when a judge has to allow continuance in the morning of trial for a new suppression issue? How do we evaluate that?
Well, yeah, there's an inertia. I understand there's an inertia to go to trial. It's probably no right or wrong answer. I know there's probably no definitive answer. There's no mechanical test. I think there was an inertia that is unhandled. I think given the seriousness of the situation, I advocate that by saying, I don't know what the standard would be, and obviously you want to get going because the jury's here to go, and I can sense the inertia to get going. My point being is with the Dilworth case, the result would express all the evidence because the violation happened before the search.
The problem is, we got to write something that will guide Superior Court judges in the future. So we would need to tell them when you have to allow the continuance. So I need some kind of standard or things to balance. I mean, otherwise it just can't be written.
Well, no, you just go back to the standard by saying that a judge cannot exercise discretion. Judge cannot use the discretion. Just cannot use the discretion to a point where, in the last example I said, deny a defendant his opportunity to mount a defense. So I don't, the timing doesn't change whether subsequently the decision hurts the defendant. So I think timing is one of the factors, but timing does not change whether or not it's mailed to the request. Timing may say, well, timing is a factor that you should have decided late, so we're going to go going forward. Too bad. That's your problem. But it doesn't change whether the merit of the issue is there where you argue day of trial or 2 months earlier. Now, I think standard will be the same as standard by saying the judge shall exercise discretion such that denies the defendant his constitutional rights, affects the counsel due process, and gives an opportunity to prepare defense.
What would have told the judge on the morning of trial that this was a meritorious motion? Doesn't seem yet to have been meritorious for Dilworth.
Well, the Judge Altman's decision, 3 days earlier, I think, if I may at some point,
Discovery, I mean, that doesn't say that it's going to succeed and hasn't succeeded yet in years.
well, no, I can tell you what's going on in the Dilworth case and go off the record if you want. I can do a 16-hour letter or whatever. I talked to Dilworth's trial attorney on Friday.
No, we have access to the Dilworth
Okay.
docket sheet, and I've looked at it.
Okay, so that hasn't been litigated, so it's not like they're dragging their feet. I mean, I think my point in this case, it's not a small issue. It's, if Dilworth is successful, this is the case. And trial attorney told me, off the record,
But to Judge Ditkoff's point, Judge Allman's decision had to do with discovery. We don't yet know whether there'll be merit to the claim. He's permitted certain discovery on that issue.
Yeah, but the point is, you don't go to trial and convict somebody when there could be, when there's a possibility it's just the case. So my point being, yes,
The discovery order by Judge Allman, you feel would have led to a dismissal in your case?
well, yes. No, not the discovery order. If you succeed on the merits, this is the case. Case goes away.
Pure speculation at this point, right? Because it's still pending in the Superior Court.
Yeah, but
So do we stay every case involving, a ruse involving race until the Dilworth case is decided?
well, it's presently 20 already stayed in the trial court. 20 of them, 20 cases that have stayed. 7 by Judge Block himself. I'd be happy to, I talked to the trial attorney on Friday, I'd be happy to, there's 20 cases, he told me, there's 20 cases that are being stayed by the judges in the Superior Court, 7 of which are done by Judge Locke himself. Judge Locke also stayed the execution of the sentence. John has not violated anything, he's free, he's not any problem.
Was your client out at the time of the denied motion to continue?
Yes, he was out, he was convicted, went to jail, and we did a couple of stay off for COVID-19. Then we did a stay order based on Dilworth, and Judge Locke allowed the stay order. He's out, no violations from March. But there's 20 other cases sitting in, there's a groundswell in the Superior Court. There's 20 other cases, that's what my trial attorney told me, that are sitting pending Dilworth. So the judges down below stopped 20 cases pre-trial, 7 by Judge Locke. There's 3 discovery orders being issued. There's also issues about emoji, what supposedly, they've got spreadsheets that only people that are arrested with a scheme of asking, men, people of color, nobody was white been arrested. The 3 major discovery orders have been allowed, and what Judge Crowder told me, counsel told me, was that they got spreadsheets that people that have been arrested are solely people of color, nobody who's Caucasian been arrested. And also they're using emojis, the pictures of themselves, and using all African American emojis, and the theory is that the police are using, you can't use your real picture, you got to use a caricature, a cartoon. And they're using cartoons of African Americans, all of them, and they're thinking that theory is that they're using that to attract other African Americans, to find them and monitor them. That's what Dilworth is at. And I just think that, yeah, you can't answer the question now, I understand that. So mechanically, how do you deal with that? It is late, you're right, from inertia. You don't just sit to come in day before trial, seeing what time. We understand that. But I think looking at the standard of what the judge cannot cut off, that if you open that door and you're successful, the result is the evidence is suppressed because the violation happens before the video being watched. The violation happens at the active side of the policy. Okay, when you're racial profiling and you have a equal protection violation, the violation happens at the time they set the policy up, which means the video is downstream of the policy, that all gets suppressed, and there's nothing in that case.
Can I ask what your other ground for the motion to continue being denied? You say that you thought your client may have a more favorable plea deal when Rachel Rollins became the district attorney. I saw no citation to authority in your brief to support that proposition. So do you have any case or here or elsewhere that says that you're entitled to a continuance to seek a potential alternate plea under a new administration?
No, I don't. I was just going equity. I just rest my grief, but it's what it is. And again, it's like I say, they already asked for the continuances. Now, it's my impression that I was talking to my counsel and trial attorney that they got some favorable feedback from the new administration. Whatever it is that's much low on the harm level as the Dilworth case.
The record isn't completely clear, but I get the impression that the Dilworth continuance motion was filed before they even walked into court on the first day of trial. Is that you understand?
I'm sorry, what?
The record's not completely clear, but I get the impression that the Dilworth motion to continue was filed before they even walked into court that morning of the first day of trial. Is that your understanding?
I understand it was that morning, I believe she got a copy of it and put the motion together before the trial. The jury not been paneling yet. And it happened like the previous Friday, 5 days prior was Judge Altman's decision. I guess they ran it to the CPCS. She got hold of it. Oh my God, let's do that. They found out the morning, Friday after the trial. It was the morning. I don't know when she put the motion together. I'm assuming that morning. And she filed it the day of trial. And yes, there is, Your Honor, there is sort of inertia. I understand that. But given the service situation of, it opens this door that if you walk into it, this is the case. So I think because the relief that could be sought with staying the case to find out whether or not the Boston Police Department were actually basically profiling the manner in which they were monitoring the Snapchat, often, especially the case, makes that important, and that gets back to the overall standard of allowing continuances and abusing discretion if you forestall and offend an opportunity to mount proper defense. In this case, that's the issue. That's abuse of discretion as I see it. Albeit untimely, there's an inertia. We understand that, Your Honor. I get that, but I think. And also, it was new. It was only 5 days old. And what's going on here? You know, forward. We understand that. And hindsight's 20/20. But in light of that, in light of a deal with getting some groundswell and the grassroots support, I think the judge could have abused discretion by not allowing the continuance. And in retrospect, what's happened with the lower court, that the remedy I think should be flipping the case, remand pre-court, put them alongside everybody else waiting in line to deal with. If you lose, he goes back to prison. If he doesn't lose, or do we try? Actually, we try him if he flips the case. But I think proper remedy is to reverse the case, put him in line with all the other 20 defendants. That's run its course. And so that's really all I have. Any further questions? I think that's all I have actually. I did address the other issue 2 regarding quickly, but like I said, regarding the other cases, to me, I think Snapchat, because it's a 24-hour, this is the piece here, it's a 24-hour issue of putting something on the internet, not a text which is permanent, or an email which is permanent, or actually regular mail, or even putting it on your website. It's a temporary thing. So to me, a person may have an expectation of privacy. They post it for 24 hours, no one's going to disappear forever. That makes objectively give a person the impression that it's private amongst my friends, captive audience, and although it could be shared, it's only a temporary period of time. That's how I kind of distinguish Snapchat, as I look at it briefly, than other cases, other forms of searching.
Thank you very much, counsel.
Thank you.
Attorney Doherty, let's give us a chance to wipe down the table. Thank you, Chief. In the courtroom, after this case, we will take a brief 10-minute recess and return with the Bizignani case. Good morning, counsel. When you're ready.
Good morning, and may it please the court. Andrew Doherty from the Suffolk District Attorney's Office for the Commonwealth. I'm asking that the court affirm the defendant's conviction. The first question the court asked was whether Carrasquillo, that's currently pending for the SGC case, should.
Hold on just a second, Mr. Pritchard. We need the clock. No. Thank you. Please continue, counsel.
It should interfere with this court's decision in this case, and I think there's a couple good reasons why
Was it your office that did Carrasquillo?
It was.
Okay.
And to the extent that perhaps I should have asked this court to stay this case or bring it up, I apologize.
We're happy to have you in Salem.
I'm happy to be here. I'm happy to talk about Snapchat and happy to distinguish this case from what I expect you're going to see in Carrasquillo, which is that in this case, the defendant didn't testify, and didn't establish that he did the kinds of things that are necessary under Delgado Rivera to determine his reasonable expectation of privacy in his Snapchat posts.
But isn't that the question, as I understood Carrasquillo in part, was whether it's an objective or a subjective standard, and won't that help inform our decision in this case?
So I would say both of those are going to require an evaluation of what the defendant did to establish that he had a reasonable expectation of privacy in it. And that's going to be the starting point.
So Carrasquillo did far more than Mr. Lewis?
Carrasquillo testified. Carrasquillo said...
at the motion to suppress.
At the motion to suppress. And he said, if I recall correctly, that I had a policy where I only friended people that I was certain that I knew. And I did not know this person. So he must have been either posing as somebody that I knew or was, or else somehow he was able to use the cedar trickery to get it. So there was evidence about both his reliance on this friend system to create a privacy for his studies, and also there was some form of deceit used to circumvent.
And so here, only the officer testified.
That's correct. That's correct.
But I would still imagine that notwithstanding, and that's a significant differential, and I appreciate you raising that. It seems to me that we would want to know, even with that factual difference, what the SJC thinks about the expectation of privacy. I know we have here the Snapchat user agreements and things like that. It seems prudent for us to wait.
Sure. No, and I'm happy to have the court do whatever it wants to do in this regard. I expect, I think in lieu of coming back again and arguing this before you, that I would ask the court to look for the following things.
Well, we could still stay it, and then when the SJC decision comes down, we could request additional briefing, certainly on that. I guess one of the questions I have is, because your office was involved in both of those, do you know if there are other, we'll put aside the continuance for a second, but Snapchat video expectation of privacy claims that are percolating in the appeals court?
I know of this case and the Carrasquillo case.
Okay, that's helpful.
I expect I would know.
Okay.
So I think these are it. In any case, if you are looking for what I would argue, if Carrasquillo goes the way I expect it to go, it was, to what extent did the defendant describe the policies and procedures that he relied on, and to what extent would that have furthered an objectively reasonable expectation of privacy? I would then likely argue that relying on terms and conditions of Snapchat were insufficient. Well,
I have to imagine that the terms and conditions also say that you're not supposed to display a gun on Snapchat.
They do, and they also warn all of their users that there is no telling who is copying this without your knowledge, and that you need to be extraordinarily careful when doing that. And although that is not before this court, if it was before the motion judge, that is one of the things we would have pointed to.
So I'm way too old to understand Snapchat, but I think both of you did a nice job in trying to explain it. In this case, this will show you I know a little bit about Snapchat. Was this part of his story?
So that's an interesting question, because the judge says that makes a difference here, right? Because the judge says there's no evidence to tell whether this was public or less public. And the officer couldn't recall whether it was private. I'm not sure he'd be able to tell whether it was private. That would have needed to come from the defendant. And Judge Ames, to her credit, I think had the foresight to expect this kind of thing and made findings. It's in her rulings that although the defendant argues that these were private, although the defendant argues that the officer was posing as a friend or family member, the evidence doesn't support any of that, and that he had failed to establish a reasonable expectation of privacy. So I think that speaks to the importance of having evidence that you're able to then evaluate, okay, that just because you used a privacy setting, what does that get you, and how much did you enforce the rules that you used in place?
Was the good faith exception that you argue here also argued in Carrasquillo?
I believe it, I'm almost positive it was. I recognize this court may not have the authority to do that, but when you're dealing with brand new technologies and new ways of determining reasonableness, I think that just shows how important having a good faith exception to would be in these situations. So I think we will be continuing to argue that in any number of cases. Unless there's any more questions about Snapchat, turning to the continuance, and there's first and foremost, just putting the new administration aside, what is clear on the record is the new administration was in place at the time that this continuance was sought. Judge Locke, it looks like at a pretrial conference, had asked and was aware of this and had asked the prosecutor to just make sure and speak with the first assistant to determine whether or not this was actually going to change. And by the time he was sentenced, remember there was an enhancement charge on here and there was a bench trial some 2 or 3 weeks afterwards. The new administration was well in place, and although it sounds like there was a plea offer offered in February, that plea was rejected, and you can see that in the transcript. So putting aside that there is no citation or authority that you can hold off and hope to get a better deal with the new administration, a new administration was in place, and still the defendant received a plea offer that he was not satisfied with. And so moving on to the more interesting issue is the Dilworth case. At the time that
what I asked your brother, it's not completely clear from the record, but I get the impression that the motion to continue on Dilworth was filed before anyone stepped into court that first day.
It's confusing, and it's confusing because the transcript doesn't show that this was addressed at all orally with the judge. What you see is a stamp at the bottom of the page that says January 23rd, which is the first day of trial, which is the day that this was addressed. It looks like the argument immediately goes to whether to continue in order to address the new administration, which the judge flatly denies, and they don't move on to this Dilworth question. I've looked more than once for some sort of discussion or argument about this, but it does not appear that that was made. One of the questions you asked was about whether to bill the trial counsel for the fact that the motion hadn't been filed by this time. And I think I want to be careful about that answer, because part of that would then go to whether it was an ineffective assistance of counsel to not have foreseen this issue and filed it. And I don't think that that's the case. I think that Dilworth was novel enough that it would have taken an extraordinary attorney to predict that a judge would make this very initial discovery ruling.
Well, we certainly have a host of police ruse cases that allow police to use a ruse. Do we have any cases that discuss those cases in the context of racial profiling?
I don't know the answer to that. I don't know the answer to that. I would say that one of there are several issues that need to be resolved with the Dilworth litigation, and to some extent, I believe that's one of the questions, is whether there needs to be some sort of constitutionally significant action and whether friending somebody on Snapchat is a constitutionally significant action in order to trigger the remedy of suppression. So, that is not something I'm personally handling. I have a secondary knowledge of all those. My brother raises some points that weren't before the judge at the time. The Dilworth was 5 days old. The discovery motion was 5 days old. And so you need to evaluate, or you should evaluate the judge's decision at the time the decision was made. But he raises a couple points that I would argue are irrelevant, but it is that there are more than a handful of defendants in similar situations to this defendant who have filed these discovery motions, and those initially discovery motions have been allowed. Those don't stay the trial proceedings. It's just that the trial can't happen without those discovery motions. So I do not have an exact number for you, but 20, I think is the number my brother used. I can't disagree with that. I can also, I don't know how many of these Judge Locke, who was the judge in this case, has allowed to go forward. I can say Judge Locke was the judge who stayed this proceeding due to the defendant's arguments in COVID, which were based off of the strength of this appellate case. And one of the reasons he did cite, just in all honesty before the court, was that the defendant had raised a preserved plausible appellate issue. And in reviewing this, he didn't specify which one that was, but I can't see that it was the Snapchat suppression or the sentencing new administration argument. Unless there's any other questions.
Seeing none, counsel, we'll take the rest of your argument on your brief. Both counsel, that was a great help to the court. Thank you both. And this case will be under advisement. We will stand in a brief recess, about 10 minutes.
All right. Court is now in session. Please be seated.
All right, good morning. Before we call the next case, for those of you that may not have been there this morning, again, thank you so much to Essex County for your warm welcome today. I am Amy Blake, and I'm joined today by Justice Gregory Massing and Justice Joseph Ditkoff. We have 3 remaining cases that are all civil. The standard rules that apply in Boston apply in Salem, which is that each party is permitted 15 minutes of argument. There is no rebuttal. For those of you that didn't hear this morning, the judges have agreed to not wear our masks during the hearing today, but have represented to you that we are all fully vaccinated. We ask that those of you in the audience that continue to wear your mask, but when it was your turn to present, you're welcome to remove your mask with the proviso that if you do so, you are certifying to us that you are fully vaccinated. So with those thoughts in mind, we will call our next case. And I'm sorry if I mispronounce this in advance. It's Bizignani versus Lynn District Court Justices, docket 21P16. Attorney Cordy, when you're ready.
Fully boosted. Morning, Your Honors. Robert Cordy representing Mr. Bizignani, who's here in court with us today. The first thing I'd like to do is clarify the amount of the forfeiture in this case. A present value determination made by the chief consultants, which has not been challenged, calculated the present value of the future payments that would be due to Mr. and Mrs. Bizignani as of the date the board was considering forfeiture. That's in September of 2017. The amount was $1,533,000 as of $533,698.
I'm sorry, you trailed off. $1,533,000.
698. Sorry.
That's okay.
And that's at page 165 and 166 of the appendix, the Ricky analysis. The present value does not include any of the pension payments between 2012, when Mr. Bizignani retired, and September 2017, which the retirement board calculated to be about $440,000, and which the board notes would have included the return of his $151,000 in contributions. The point is that the district court, in its decision and in its brief, continues to subtract the $151,299 from the present value of the future payments, and that is simply not correct. We are dealing with, at a minimum, $1,533,689, plus the value, uncalculated, of health benefits, which I can assure you is very significant, and life insurance. That's the forfeiture.
I'm sorry, I'm not following. Why doesn't the return of the $151,000 count?
It's already been returned. I mean, he got $440,000 already, which included his return of $151 plus another $290.
I see. It's not being returned because you already got
Yes,
the pension.
exactly, because he already got it back.
1.5 is only going forward, not the return.
Correct. Thank you.
I understand.
This brings us to an initial sort of big picture analysis. The forfeiture is more than 15 times the maximum fines that could have been imposed under the statutes to which he pleaded guilty. It was $102,500, and more than 25 times the $60,000 in fines actually imposed.
Can I ask you
Yes.
about sort of your underlying argument? I certainly understand your argument under the Eighth Amendment as an excessive fine, but our statute, my words, not the SJC's words, is sort of an all or nothing statute.
Mm-hmm.
And following, I believe it was the Bettencourt case, there was a lot of, in that opinion, saying, hey, legislature, you need to do something. And we have in the record, things did happen, and unfortunately, it didn't go anywhere.
Mm-hmm.
Aren't our hands tied?
No, not at all.
Why?
What the legislature has chosen to do is to continue with an all or nothing proposition, and therefore run the risk of an excessive forfeiture in violation of the Eighth Amendment.
So let's follow that line of thinking. assume for the sake of this question that we agree that it's an excessive fine. I have no idea what we're gonna do, but let's assume that. Do we then have the ability to say, you know what, instead of $1.5 million, it should be 600,000 or 200,000 or 900,000? Or do we say, oh, it's an excessive fine, zero?
Bettencourt. That's exactly what the court was struggling with.
Right.
Bettencourt saying, well, the court would have the authority to lower the amount to something that would satisfy the Constitution, but it would be best to leave that to the legislature, really a directive, an admonition.
Absolutely.
And because if they don't make those adjustments, then we're going to have to say nothing sometimes.
So is it your view in this case that the answer is zero?
My view is the answer is zero. Would a partial forfeiture, some forfeiture be appropriate in this case? I would say yes. Some forfeiture is not an option. It's all or nothing.
There's nothing keeping the legislature from creating a partial forfeiture scheme and then it being applied to people who've already been convicted of crimes. Or maybe there is.
Well, that's interesting. I hadn't thought of that. You mean sort of a retroactive benefit? I don't know. I don't know why the legislature hasn't acted on this. It's a very well-crafted approach, which deals with the problems that the SJC recognized in the Bettencourt case.
But the facts here are, in my view, so different from Bettencourt, right? Bettencourt was trying to figure out what his colleagues got on a promotional exam. I mean, your client certainly faced a significant sentence, but as I understand them, all of his crimes had to do with his role, his akin to a fiduciary role as a town manager or a town administrator in awarding bids, in procuring supplies, and then when tipped off, at least as I understand the allegation, and not looking at the supplemental appendix supplied by your brother, there was at least allegations that he was destroying records, altered documents before the grand jury, tried to influence someone's testimony. So when he got caught with his proverbial hand in the cookie jar, he didn't take it out, he doubled down. That's very different than what Bettencourt did.
Oh, I agree. I agree. That's different than Bettencourt.
Which is why zero is really a hard place for me.
Well, I understand that. It's not your fault. It is the legislature's fault. What we have here, again, is at least 15 times the maximum. Now, as we pointed out in our brief, in the Supreme Court, in the context...
Why is, I mean, I don't understand why the fines are the right thing. There's no fine for murder or manslaughter or child rape. So it wouldn't mean that you couldn't have any forfeiture if someone, a school teacher, committed a child rape of a student. I mean, don't we have to look at the sentence and compare that to the fine?
Well, that's why there's no bright line, because there are different act sequences that might result in a forfeiture. Ordinarily, forfeitures are involved in cases in which there has been some significant financial issues, penalty issues. The case of U.S. versus Barraza, which is an 11th Circuit case cited by my brother in their brief for a different issue, really has a thoughtful explanation about how they apply forfeitures. And they basically say if it exceeds the maximum fine, it requires the closest of scrutiny, noting that it is only upheld forfeitures that were up to twice the maximum authorized fine. The U.S. Supreme Court in the State Farm case in the context of civil cases and punitive damages, opining that ratios between punitive and compensatory that exceed single digit are likely not to comport with the due process clause. So there are some limitations here, for sure, and at some point they begin to apply, and I would suggest that in this case, they absolutely begin to apply, particularly where there's no financial harm to the municipalities, no personal gain by him.
How do we know either of those things? If we don't look at the supplemental appendix, we know nothing about these crimes other than the indictment language. How do we know that there isn't personal gain, and how do we know there wasn't harm? There's certainly kind of crimes that normally do have those things.
Right. They might, if that was the point. If the point is, I'm the manager, we need things done, I can get things done efficiently without having to worry about all this other stuff, which is this case. I don't think the Commonwealth suggested there's been fiscal harm to the cities.
How do we know that without looking at the supplemental appendix?
Well, there was a whole process, a charging process, guilty plea process. No restitution has been ordered. There was no evidence of financial harm.
How do we know there's no evidence of financial harm? We know there's no restitution, but that's sort of the only thing we know about the crimes, unless we look at the supplemental appendix.
Well, I don't know whether the supplemental appendix is going to help you on this issue. But I don't think there's a challenge to the fact that the municipalities did not suffer any financial harm.
What about the public trust?
Definitely a harm, for sure. And that's why I say some forfeiture might well be appropriate. But we're not dealing with some forfeiture. We're dealing with an enormous forfeiture, which gets to the other point of whether or not.
Before you get to the other point, on this point.
Yes.
It's your burden at the district court to show that the fine was excessive, right?
Right.
So what was the showing in the district court?
Well, I mean, the showing in the district court was exactly what we're talking about. No harm to the city, no financial benefit.
How'd you show there was no harm to the city, the district court?
No harm alleged.
By who?
By anybody. And no restitution. And nothing in the plea colloquy which would have suggested there was fiscal harm to the city. I don't think, based on this record, you can conclude that there was some fiscal harm.
How can we conclude there was no fiscal harm from this record? It says nothing.
There was no evidence of fiscal harm.
But wasn't it your duty to present the evidence? If there's no evidence, don't we have nothing, and it's your burden?
I don't know how to respond to that exactly, because all the way through, I think everyone has assumed that that's correct. That if there had been harm to the city, it would have been raised at the sentencing. It was not raised at the sentencing.
How do we know it wasn't raised? I mean, I know you didn't litigate this before.
No.
So I mean.
We don't have transcripts, for example, right?
Exactly. No, we don't. In any event, I apologize that I can't give you bits and pieces of what happened before the board, actually, the retirement board. But one of the things that we know is that the forfeiture took effect 2017. Mr. Bizignani was 71 years old. This was 35 years of service. This was his livelihood. And to deprive someone of their livelihood, as we've discussed in our brief, is a real problem. That's the reason that the excessive fines and penalties clause is in our Constitution. And it is a separate issue from whether the conduct was so gross that if this fine was not excessive.
Could I ask you, though, back on what Judge Ditkoff was asking about with the district court? At Record 301, the district court says the crimes involve substantial breaches of the public trust. They violated the most basic ethical responsibilities of his position. This harm to the public trust is as important as the potential monetary harm caused by his actions.
Yep.
And then Mr. Marks argues that there was a pecuniary harm in terms of the cost of investigation, the cost of prosecution, and things of that nature. Are those improper considerations?
Our courts here have not considered those, and there's no evidence as to what those costs might have been, for sure.
So you have focused on a multiple of the fine. What do we do with the fact that, and I think you don't dispute that the maximum penalty that your client faced was 54 years in prison. And granted, he got probation, and Betancourt tells us we don't really pay attention to what he got versus what the maximum penalty was. How does your argument change, if at all, when we look at the maximum punishment he was facing in terms of prison?
Well, I think you have to look at what the sentence was. Yes, that's a lot of years packed in there, 54. And he got 0. So
he got probation.
Yeah, 2 years probation, I'm sorry, and a $60,000 fine. That has to reflect somewhat on the seriousness of the event. It can't be complete discounting.
Did he successfully complete his probation? Is he off of probation?
the other point I was trying to make is the, Chief Justice Lynch wrote a very good opinion talking about why deprivation of livelihood is a separate issue from whether the forfeiture is grossly disproportionate to the conduct. It's the case of U.S. versus Levesque, 2008 First Circuit case, and really worth the read as a complete separate analysis from the grossly disproportionate part related to the seriousness of the offense. In any event, I really do think that where there's no evidence of financial harm, no evidence of personal gain, and no incarceration, the proper way to assess proportionality is to look at the ratio between the maximum fine and the amount of forfeiture.
Only because we're running out of time, could I ask you, you make arguments about your client's sort of station in life. What do we have in the record about his wife's, what you say his wife's innocence is, and the limitation on his retirement earnings? Do we have, are those by inference, or do we have direct evidence of that in the record?
It's largely by inference. He did not participate in any other retirement programs.
Okay.
That we know about, or that we're certain of. Could I just point out the recent case of State Retirement Board versus Finneran, because that's the one case decided after Betancourt. And
I'll give you 1 minute to wrap up on Finneran.
No financial harm, no financial gain, no incarceration. But there was a forfeiture of $433,000 in pension benefits. And the court underscored several times that this is because the maximum fine was $250,000 within the 2-to-1 ratio.
Thank you. Thank you, Mr. Spady. Good morning, Mr. Marks.
Good morning, Your Honors. May it please the Court. David Marks, Assistant Attorney General for the Lynn District Court. To start where plaintiffs started off.
Well, can I ask you a preliminary question? You may not know the answer to this. Is this the largest pension forfeiture of which you're aware?
This is the largest that I'm aware of in Massachusetts in the reported cases.
And of the cases that both of you cite, which are all similar, this is definitely the highest?
Yes.
Okay.
Now, Flaherty is very close.
Right.
Flaherty was a forfeiture of over $900,000, and Flaherty was the highway director for a city. He was convicted of 1 count of larceny over, carrying a maximum of 5 years in prison. And the crimes he committed, stealing the property of the city's highway department, amounted to personal gain of $600. That was not an excessive forfeiture, according to this court and the Supreme District Court. This certainly isn't. Where the plaintiff here committed 12 different crimes in the course of his acting as the chief executive and chief financial officer for the town of Saugus, and then continued to commit the same crimes in the same capacity for the town of Nahant. Those crimes, procurement fraud, public bidding law violations, municipal finance law violations, were committed over the course of 5.5-year period while he was serving in both of those positions. And then
we have those crimes without what I'm going to say is the obstruction-related crimes. Would you say that the forfeiture would still stand?
Absolutely.
Okay.
Absolutely. This is the quintessential case where pension forfeiture should apply.
And then, so how do we then assess the additional obstruction-related offenses?
It's even worse.
Do we have, Betancourt, we don't have it in Betancourt, Finneran, or Flaherty, right?
No.
Okay.
No. This is on top of what you have in those cases. Here, on top of his committing the crimes that went directly to his ethical responsibilities in those positions, he then committed 4 additional crimes intended to obstruct and undermine the investigation, which itself does not reflect well on a high government official.
And he pled to all of them.
He pled guilty to all of them, 12 counts in total. So on this record, the plaintiff simply failed to carry his burden of showing that this forfeiture was grossly disproportionate, and that's the language from the United States Supreme Court, to the gravity of his crimes. And the gravity of his crimes, according to all the case law, is determined by 4 factors. One is the nature of the offense. The second one is whether the crimes were related to other illegal activity. These crimes were all related on an ongoing basis, as were the substantive crimes related to the obstruction crimes. What was the maximum sentences, not the actual sentence. The case law is clear that the excessive fine analysis does not take into account the actual sentence, and the harm resulting. And clearly here you have harm to the public trust, you have undermining of public justice in the obstruction crimes, and you have clearly potential harm to the public fisc, because these crimes he committed are intended to protect the public fisc. And moreover,
Do you agree that there was no personal gain to the retiree?
Well, there's no evidence on this record of any personal gain. That's all we can say, because the plaintiff had the burden of showing that this was an excessive fine. He would have had the burden to present evidence that there was no personal gain, and he failed to do that. He's also...
Do we need the bill of particulars to decide this case? Can we decide it without that?
You do not need the bill of particulars.
And you say we can take judicial notice of it?
You absolutely can take judicial notice of it.
Did the district court take judicial notice of it?
Not the district court, no.
Did the Superior Court?
No, the Superior Court declined to.
Declined to.
That's right. So I wanted...
But even if we take judicial notice of it, how do we know that that's what he pled to? I mean, that's what you accused him of, but you have a guilty plea, and there's a colloquy that we don't have. How do we know he necessarily pled to all that, or part of it, or said, yes, but?
Right. What we know is that the Commonwealth bound itself to prove what was in the bill of particulars. And by pleading guilty to all those counts in light of the bill of particulars, you certainly can find that the contents of the bill of particulars amount to substantial evidence regarding what happened. Do we know whether he actually admitted that he committed every little act described in the bill of particulars? We do not know that.
You know what happened to the plea colloquy? I mean, there's discussion at the board about let's get the plea colloquy and hold it open until then, and then it kind of disappears. I don't know if we know, but I'm curious.
This is the dirty underbelly of this case, okay? What you have here is a board that took the position that it had no jurisdiction to address the excessive fine issue. So therefore, it appears...
You're right about that.
I'm sorry?
That's correct, right? The board doesn't do that.
The board, yes, the board does not make that constitutional determination in the first instance. But as a result, it presented it included no additional evidence regarding the underlying facts of the crimes before the board. And when it defended the case in the district court, it failed to produce evidence, as it was entitled to, because the district court was having an evidentiary hearing. It failed to produce any additional evidence, the plea colloquy, the bill of particulars, et cetera. So we are, in a sense, stuck with that. However, there's no question this court can take judicial notice of the contents of a related file. I just want to add a point on this notion of whether it should be included in the record appendix. There is no question this material should be included in the record appendix. The rules of appellate procedure say that the materials included in the properly included in the record appendix are materials that were in the record below related to the issue on appeal. Clearly, these materials are related to the issue on appeal. That is, the excessiveness of the fine.
Aren't you still asking us to make a factual determination? I mean, we're supposed to be reviewing de novo the action of the district court. Like, I don't think we're supposed to be finding facts at this level.
Well, you certainly can, again, as the SJC did in the Bonomo case, you certainly can look at the contents of the court files. It would be particularly distressing if the forfeiture was overturned without taking into account the actual facts as they are shown in the Superior Court file. But no, I mean, I'm not asking you to make fact findings.
I've been in your shoes, and but I mean, we wouldn't be overturning it. If we did, it would be because the record below wasn't sufficient.
Right. And the problem here is that on all of the arguments the plaintiff makes, either they are simply not supported by the case law as relevant arguments, or they are not supported by the record below because the plaintiff failed to make the record or he's misconstruing the record. So, for example, this notion that the forfeiture is $1.5 million, the district court found as a fact that it was closer to 1.38. There's no argument here that that finding was clearly erroneous. It may have just stood up today and said that, essentially, but it's nowhere in the brief. We can't just ignore the facts found by the district court. That was a fact found by the district court.
Do you disagree that the 151 wasn't actually repaid because it had already been paid out in benefits?
Well, theoretically, if the entire pension is forfeited, yes, theoretically he gets to keep that 151. But there's no reason to believe that the valuation did not include what was previously paid as part of the entire pension. That's the problem here. But it doesn't matter because the district court.
Do we have to resolve that? I mean.
You don't have to, no, you don't have to resolve anything.
Agreed, it's all or nothing, and so if it's all, the number is what the number is, right?
The number is what the number is because the district court made a finding. There was also no evidence regarding the plaintiff's other retirement savings. Despite what he says, the only indication of that was that he's not eligible for Social Security as a municipal employee. There was no evidence regarding his other assets. There was no evidence regarding his wife's innocence or not. It was totally legally irrelevant what his age was. In fact, in the vast majority of these cases, these issues are going to arise when the retiree is likely to be older than others. But age alone.
Under the nature of the offense factor, is that where you would place the fact that it was two different municipalities and it was a scheme over multiple years?
Yes, Ron. Yeah.
So all these spreadsheets start with the retiree being 71. So isn't it plain that they only are talking about future benefits, not already received benefits?
Again, I cannot, maybe yes. I can't remember precisely what the actuary's report was on that. But again, this is the finding that the district court made regarding the total amount.
On the factual record, he went to Nahant after he retired. He was like what do you call it, 960 employee or something like that. So he would still get his pension and get paid.
Yes, Your Honor. Yes, Your Honor. And basically continued the same crimes he was committing in Saugus in Nahant, corrupting the finances of two separate towns.
Do you think, I mean, it's obviously part of our record, but do you think that, crimes you commit after you retire are therefore not, crimes that involve the job that you were earning the pension on? If he hadn't done the procurement fraud before he went to Nahant, would he be eligible for losing his pension?
Well, I think the short answer is yes, because he's acting in the position of a public employee. So it would comply with the language of Section 15.4. But I think Bonomo also addresses that, because actually in Bonomo, the position he was serving during which he committed larceny was after he had retired from the, I want to say, city of Somerville. And it was the Somerville retirement allowance that was being forfeited. So I actually think...
But the crime was from when he was register of probate.
That's right. And I actually think the Supreme Judicial Court addresses this in Bonomo. Okay. In any event, this notion that, even assuming there was no personal gain, should play a role. Clearly, it is part of the calculus. But the courts have said it doesn't matter if it doesn't exist. So, for example, in Marr, the court said, as the district court said here, the potential harm to the public trust caused by his crimes is equally important to our analysis as any potential harm his actions might have caused to the public fisc. Finneran noted that there was no evidence of any harm, period. But nonetheless, the Supreme Judicial Court said his crimes, federal crimes related to obstruction of justice, related to his role as a speaker, warranted the forfeiture there, and it was not an excessive fine. But the SJC specifically said we have no evidence of any harms.
And I think we're going to have to leave it there unless there's any other questions from the panel. Seeing none, counsel, thank you both very much. The matter is under advisement. Ron? Do we know if that lawyer made it up yet?
How does that, haven't found it yet?
Okay. Just give me the high side.
Okay.
Carrie, still good?
Thank you.
Tom, we okay?
Thank you, sir.
We call the next case Inbox Insight Incorporated versus Demand Dogs LLC and others. Docket number 2021P0179. Counsel, I'm not sure if you heard, you are welcome to take off your mask during argument, but that in so doing, you're certifying that you've been vaccinated. So with that, when you're ready, counsel.
Thank you, Your Honor. May it please the court, my name is...
You should come right up to, yes,
Sure.
I'm sorry about that, right up to the podium. We've had it cleaned.
Thank you. May it please the court, my name is Ronald Dunbar, and I represent the appellants, Demand Dogs, Tracy Kohler, and Keith Smith. The trial court erred in granting judgment on the pleadings with respect to Inbox's complaint for contempt. And this court reviews that de novo.
Can I ask you, Attorney Dunbar, don't take a lot of time with this, but could you give me 30 seconds of what this business is?
Oh, boy, I was worried you were going to ask that. I've been dealing with this case for years. These are companies that provide leads to customers. So if you are ADP and you want people to sign up for your ADP service, they will send out marketing through email, some telemarketing to get customers to express an interest in using the ADP service, and they'll provide those names and contact numbers to ADP for ADP then to try to get people to subscribe to ADP. And the difference here is agencies, it's like a media agency. They'll have ADP, they'll have, PDF Acrobat, they'll have a bunch of customers that the agency will provide to our clients who then can get business and leads from us.
But the agency pays.
Excuse me?
The agency that pays Demand Dogs and Inbox.
It would be the agency that pays Demand Dogs, yes, and Inbox in those circumstances. So it's an industry I wasn't familiar with, but I think that, contempt is a very unique situation. And even the trial judge said, I've never seen a motion for judgment on the pleadings in a contempt proceeding, and I haven't seen any in the Commonwealth either. And I think there's reasons for it because it requires clear and convincing evidence on the part of the plaintiff to show that there was a violation, and the order has to be clear and unequivocal, and the violation has to be equally clear and unequivocal. So it requires such a heightened...
Oh, wait a minute. The order has to be clear and unequivocal. The disobedience has to be willful, right? That's different.
It's different, and it's different, but it requires a factual analysis, not just an answer and a complaint. And I think Rule 65 even talks about that, 65.3, and I cite in the brief.
So that's where I get confused, because there was an evidentiary hearing in this case. What was the evidentiary hearing pertaining to?
And that does lead to some confusion. There were 2 complaints for contempt.
Right.
All the conduct occurred before the first complaint for contempt was filed, but Inbox decided to file 2 separate complaints.
Am I wrong that the second contempt only dealt with, I think it's lead scale?
You are correct. It only dealt with lead scale. And more importantly, this is the most important issue, it only dealt with the issue of whether Mr. Smybert, who worked for Demand Dogs, contacted lead scale. The judge had indicated...
You're ahead of me a little bit.
Sure.
On the first contempt, am I wrong that your client stipulated that as to transmission, NESOC, OMD, Old St. Street Marketing, everything except for lead scale, they stipulated that contact had been made in violation of the preliminary injunction?
That I'm unsure of. There were some stipulations. I think there were stipulations that those individuals were contacted. I'm not quite sure because it wasn't germane.
So if there's a stipulation to that effect, isn't that the contempt right there?
No, the stipulation wasn't to whether an agency and a customer are the same thing as it appears in the order, and that's the issue. So the first contempt trial was decided on the pleadings, on a motion for judgment on the pleadings. And the judge found, without any evidence, with no testimony, that agency is covered under the order, even though the word agency appears nowhere in the order.
It says customer.
It says customer. That issue was decided in the first contempt proceeding that was decided on judgment on the pleadings. The second evidentiary hearing, the judge said beforehand, I'm not changing my decision on that. I realize it's on appeal. So the only issue in the second hearing was whether Mr. Smybert contacted lead scale. The judge was not going to change his ruling that agency is a customer.
On the first contempt, it seems to me that figured prominently in the judge's findings were the admission by your client to paragraph 11 and 15 of the complaint that says Overdrive and Kingpin are, quote, agency customers.
Correct, and I think...
And your clients, you're admitted that they were agency customers, which is the word customer.
Right, so they admitted that they were agency customers, but also denied in the same answer the factual allegation, which is the defendants cannot in good faith distinguish agency customer from any customer. And that was denied. And on a motion for judgment on the pleadings, if you deny a material fact or assert a defense, which they also did with respect to the order, that it wasn't clear and that the disobedience wasn't unequivocal, that motion for judgment on the pleadings is inappropriate.
Do you have a case, right, do you have a case that says that? That
It
you
says-
can't enter a judgment on the pleadings on a contempt?
There is no case that says that, and that's, and I've searched for it. The judge had never seen it. I have never seen it. But Rule 65.3, the language seems to suggest that you need a trial.
You're assuming it's a factual question, what the preliminary injunction order means. Why isn't it a legal question, whether it clearly unequivocally bars any customer, including agency customers?
Because it contained, there was a lot of, at the preliminary injunction hearing, there were submissions as to what's an agency, what's a customer, and the judge's order specifically used the word customer, and the judge also found that if I was to...
No, I get why you think the judge got it wrong.
Right.
What I want to know is why you think it's a factual question rather than a legal question. I understand why you think the judge got it wrong legally, but is it a legal question or is it a factual question? What's the clear and unequivocal meaning of the PI order?
I believe it's a legal question, that whether the order is clear and unequivocal is a question of law for the court to decide. And if you read the initial, and the judge that decided the motion for judgment on the pleadings and had the second contempt trial did not issue the injunction. If you read in the record, the injunction, it's more than just at the end where it says you're not to contact any customer. The judge further says, if I was to grant all the relief that Inbox has requested, I would fear that I would put Demand Dogs out of business. So they can't talk to any customer at Demand Dogs that they talked to while they were at Inbox. And the question I answered at the beginning, these agencies have lots of customers underneath them. If an agency came to Demand Dogs under the order as Demand Dogs understood it and said, here's a customer, and they said, oh no, we dealt with that customer at Inbox, we don't want that. But if the agency gave them another customer that they didn't contact at Inbox, they could take that customer. And that, because agencies control so much of the market.
Just to bring it home, you want us to find that this wasn't clear, unequivocal as to agency.
Yes.
Not to send it back for a trial.
Well, to send it back for a trial because there's facts that were testified to at the second trial.
I just mean the first one. Yes, I understand
Yes.
The second one we do have a factual issue.
Right. And I think because, whether there is a clear and undoubted disobedience does go to sort of the intent of the Demand Dogs individuals. So the less of, explicit intent to violate an order, the more likely the courts to find that there wasn't a clear and undoubted disobedience. And the testimony of Mr. Smybert was, in this industry, there are agencies and there are customers. And agencies have lots of customers. And agencies control so much of the market that if you eliminate those from what Demand Dogs can contact, even if the underlying customers they never spoke with at Inbox, they would essentially be eliminated from a huge part of the market. So that's the argument. And I think it was all compounded by the fact that this was decided on a motion for judgment on the pleadings when there was a specific denial of a material fact. And the case law says if you specifically deny a material fact, you can't enter judgment on the pleadings. And we could have had what happened at the second trial just happen all at once with testimony as to what's an agency, what's a customer, and whether, obviously the contacting of lead scale was the second part of that issue. So
after the PI issued it, there's nothing in the record that suggests that your clients went back in for clarification, right?
Right. And I think that it's because in their mind, if Mr. Smibert's testimony is in the record, they weren't confused by it. They're like, okay, we know what agencies are, we know what customers are.
They were not. I just want to make sure, they were not confused.
They were not confused. They didn't think there was any ambiguity. They knew what agencies were, they knew what customers were, and they knew if an agency had referred a customer that they had talked to while at Inbox, they'd turn it away. But there might be, and there are lots of customers that they wouldn't have to turn away. And I think the judge who issued the injunction was so sensitive to that. He goes on, Inbox was asking for so much, I'm going to limit it to any customer you talk to at Inbox, you can't talk to when you're at Demand Dogs. So I think I've covered sort of both my first two arguments that.
You might not be prepared to answer this, but I'll give you a shot in case you are. There's a U.S. Supreme Court case that says that a notice of appeal has to be filed within 30 days of the original order. It can't wait until the attorney's fees. And at least for the second contempt, you didn't file your notice of appeal until 30 days had passed after the initial order. You waited till the attorney fees were issued. If you're prepared on this, I would like to hear what you can tell me about appellate jurisdiction. If you're not, I certainly understand.
Yeah, I'm not prepared for that, but I would say that, once judgment entered, on the docket, the notice of appeal was filed within 30 days. I don't believe judgment had entered until the attorney's fees aspect of it was incorporated into the court's judgment. But I'd be happy to file a letter subsequently to oral argument on that particular issue if you would like that.
Gives the opportunity to both sides to file a
Sure.
16L letter on that issue. If you could do that within 14 days, that would be helpful.
Absolutely. So I've dealt with why it was inappropriate for a motion for judgment on the pleadings to decide that issue.
So, in terms of what a customer is, which I think you said was a legal question. I mean, you don't, in a contract dispute, right, in reading a contract, you don't look for parole evidence until you decide that a term is ambiguous. So is our first question whether the term customer is ambiguous? And can you say that it is ambiguous without introducing parole evidence?
It's ambiguous in the context of this industry. So customer is not agency. And the case law that talks about contempt because of the sanctions that can be imposed, you can't read a word into the order, you can't expand the order, and the word agency is just not there. So it's customer. And it wasn't ambiguous to my clients, and it wasn't ambiguous to Mr. Smyberg, who testified at the second trial, that what a customer is a direct customer who comes to us like ADP, and an agency is like, Media World, who brings us ADP and 5 other customers. So there wasn't a clear and unequivocal order as to agencies, and there wasn't a clear and undoubted disobedience from the demand dog's defendants.
But does Media World bring you ADP, or does you provide services to Media World and they deal with ADP?
You provide the leads to Media World, and Media World then provides those leads to ADP. But it's not, the demand dogs is not blind to the customer. They know, and there was some testimony like who the customer would be, so they could make the decision. Okay, we have an injunction that says we can't talk to this customer, we talk to an inbox. Media World, we can't talk to ADP, but we can talk to Xerox.
So I'm sorry to drill down on this.
Sure.
Could you give me an example of when something would be an agent but not a customer?
So Media World would be an agency, and they're always going to be an agency. And Media World's clients that they bring to demand dogs would be the customers.
But
so
wouldn't Media World be a customer of demand dogs?
Not in the way they describe it in this industry. Mr. Smyberg said, no, there are agencies and there are customers. And,
so then what's the legal relationship between demand dogs and Media World?
It's an agency that provides them with the service of access to various customers. So they have a contractual relationship.
But Media World was paying them, not them paying Media World.
So Media World would be paying them, would be paying demand dogs.
Right. But they're a client, but not a customer.
They refer to them as agencies. So.
Well, they refer to them as agency customers, agency clients, agencies.
Right, and I think, well, the important thing, for the contempt and the order, and I'll finish with this, is that it has to be clear and unequivocal. And then from my client's perspective and from the plain language of the order, the word agencies appears nowhere and would effectively do what the judge was trying not to do, which would put them out of business by precluding them access to many customers.
I think we will leave it at that. Thank you. Thank you, Chief. Good afternoon.
Indeed, it is the afternoon.
It is.
Good afternoon. Stephen Venema on behalf of the plaintiff Inbox Insight. I think I'd like to start by addressing head-on this issue of whether agencies are customers. Of course they are. You guys saw it in the record. They've called them, and the admissions in answering our first contempt complaint were that these are agency customers. That's the term that was used in the contempt complaint and that was admitted to.
So to use the hypo, Media World is an agency customer of Inbox, and ADP becomes a customer of Inbox as a result of the agency-customer relationship with Media World.
No.
Okay.
ADP is always a customer of Media World, and Media World is Inbox's customer. A better way to frame it, in my view, is that through agency customers, a company like Demand Dogs and Inbox gain access to a whole universe of their customers downstream. But the agencies are providing a different service. The agencies are planning a campaign, helping develop content for a campaign. What Inbox and Demand Dogs are supplying to the agency, which as part of that service that the agency is providing to its downstream customers, is here's all the leads that are going to be qualified leads that you can call on for this sales campaign that you're running for your downstream customers. But the notion that these aren't our customers is belied directly by Mr. Smeibert's own testimony, where in the
But I guess that's, the fact that we're having this discussion, doesn't it make it ambiguous as to what customer means in the PI?
No, it can't, because the PI is so clearly addressing any customer.
Any customer that either the three named defendants or any other Demand Dog employee, agent, or representative had any contact with while that person was employed by Inbox until the end of 2019. So it doesn't distinguish between agency customer or downstream customer, it just says customer.
It doesn't distinguish between any type of customer at all. So if we did business with one of the agencies in the case is Just Media, and in fact, one of the defendants in the case, Tracy Kaler, was specifically assigned to be, her title was Agency Account Manager. She was responsible for Inbox's relationship with agency customers. Other people pursued different types of customers, but importantly, the order doesn't say any, they are the ones who want to add language to the order. It says any customer, meaning any retail customer, any technology customer, any agency.
You don't have contact with the so-called downstream customer, is that correct?
That is correct, and that actually...
It'd be impossible to actually have this apply to a so-called downstream customer because you would never have contact with them.
And in fact, there's evidence in the record that was introduced during the evidentiary hearing where the issue was Mr. Smeibert's contact with this customer lead scale. One of the pieces of evidence of his contact with that customer lead scale was he had called on a direct downstream customer of lead scales. And that downstream customer said, do you work with lead scale? Because that's who we use for our campaigns. Why don't you talk to them? And he responded to the question to hit on the only fact issue before you as far as, what you have to consider from a clearly erroneous standard of what Judge Davis ruled, or found, I should say. What Mr. Smeibert said in response is, I used to work with them at my old company, Inbox Insight. So it's really important to understand, too, in the context of the record before the judge on the preliminary injunction hearing, there was a former Demand Dogs employee who a former Inbox employee who had joined Demand Dogs and then since left. And he submitted an affidavit in support of our motion for preliminary injunction in which he described what an agency customer is. And he described the fact that agency customers are particularly desirable in this industry for the obvious reason that you don't have to go picking off the ADPs and the technology customers and the retail customers. You work with the agency. The agency is your customer, and you don't have to worry about trying to get access to those downstream customers. And this also highlights one of the problems with their purported understanding, that it unambiguously excluded agencies, because no way could it mean that they would be prohibited from contacting those customers of the agencies.
So what relevance is the stipulation of demand dogs to use your word, downstream customers, to the contempt?
Well, what demand dogs stipulated to is that the agencies are the ones paying for the service.
Okay.
The agencies are the ones who we bill. We bill the agency pays for our service. That is what makes them our customers.
With the exception of lead scale. They didn't agree to that.
Correct.
Okay.
Correct.
That stipulation made subsequent to the first contempt finding?
So, yes. So the way the two contempt orders came down was, first, we learned of the contact they were having post-injunction with Kington and Overdrive. I wrote a letter to Mr. Dunbar, and he said, no, these are agencies and they're not covered. So we filed the contempt complaint. In the answer to the contempt complaint, there were no material facts in issue any longer as to, all that was left for the court to do was decide as a matter of law, as we all agree, whether the term any customer included in it agency customers, because the answer to the contempt complaint admitted all of the material facts as to the fact of the contact during the time at Inbox. I mean, importantly, the people who made this contact, their job at Inbox, as I mentioned before, was to be an agency account manager. They then go to Demand Dogs, and there's an injunction that says you can't contact any customer that you had contact with at Inbox. Any customer would be inapplicable to those employees if it meant what the defendants are arguing. And so, I mean, you have to imagine, they say and this isn't even relevant really legally because their good faith has nothing to do with this, but you have to imagine, wait, my whole job is to contact agency customers. And this is saying I can't contact any customer that I had contact with while I was at Inbox. Okay, I need to do a different job here. I need to contact downstream customers, or I need to contact specifically tech industry customers. But clearly I can't be contacting the customers that I was contacting while I was at Inbox. Otherwise, the injunction would have no meaning whatsoever. It wouldn't have prohibited the conduct that was the issue that brought us to court in the first place.
What was the meaning of the judge's added statement saying, and I'm limiting it to customers that they had previous contact with because I don't want to completely put them out of business, but does...
I think I don't want to put them out of business piece is added by my brother somewhat. What the judge was getting at is the goodwill that we're seeking to protect. When you're enforcing a non-solicitation provision, really what the judge was concerned with, I think, is enforcing a non-solicitation restriction as opposed to a non-compete restriction. What he was saying is, if you've been in contact with these customers while you were working for Inbox, then now that you're at Demand Dogs, those are the customers you can't be in contact with, because to do so would be to leverage the goodwill that Inbox developed with those customers through your employment relationship, goodwill that Inbox had contractually protected in the contracts we rushed into court to enforce when we sought the injunction in the first place. So for any customer to have any meaning at all, it has to apply to all types. And again, importantly, the very defendants we sued here, Tracy Kaler being one of them, if there were questions as to this ambiguity, it was incumbent on these defendants to come back to court and say, hang on, I do agency customer work. That's what I did at Inbox. My customers at Inbox were agencies. Am I allowed to do that? And the law is very clear on this. Failing to do that, particularly where you have a clear and unequivocal order that says any customer, that has to mean any type of customer, they needed to get clearance to go forward if they truly believe that this order says what they say.
Firm. How much is there left to try?
So the remaining issues for trial are all the other customers that they solicited in violation of confidentiality obligations. A fundamental, and I mean, this is the key distinction. You know, you have a trial to resolve issues of fact. We had a mini evidentiary hearing to resolve the only issue of fact on the contempt, where it was a question of contact with lead scale. The remaining issues to be tried are the factual issues in the case relating to Mr. Smith's breaches of fiduciary duty in his performance of services for demand dogs while he remained an employee at Inbox. There's a lot of contact that they were having with customers prior to the entry of the injunction. That's clearly not within the scope of the contempt proceeding. And then there are customers that they contacted. We have a whole list of the customers that they contacted based on reliance on confidential information that they had taken. And, you know, these are issues that I thought at some stage of this case that maybe we had a summary judgment motion in our favor, an affirmative one, but no, these are going to be tried.
There's a lot to try.
Exactly. And what's different about what was here on the contempt proceedings is that there were no facts to be resolved. And I haven't heard anyone identify what those facts could have been other than what we addressed through Mr. Smibert's testimony as to the nature of the contact that he did have with lead scale when he was working.
Can I just circle back on the stipulations thing, just to be clear? The stipulation could have had no bearing on the judge's decision on the first contempt because that decision was made before the stipulation.
Yeah, that is correct. Yes, the stipulation was entered as part of the evidentiary hearing. And again, you know, the facts before, actually, it probably is useful for the court to understand the facts before the judge on the motion for judgment on the pleadings were focused on only overdrive and kingpin, as to which the contact that they did have both pre and post injunction while they worked at Inbox and then while they were at Demand Dogs, there was no dispute as to that. We then learned through an order entered by the judge that the defendants produced a supplemental customer list, that the scope of contact that they were having in violation of the injunction was broader than what we thought. And that was fundamentally what led to the second contempt proceeding, because Judge Davis said, look, we were only focused on overdrive and kingpin. If you feel you need further relief, come back. And so that's why there's the two separate contempts.
I'm curious about the process, though, because I know your brother argues that they were entitled to a trial, and I think you cite Mahoney and other cases that say contempt does not necessarily need to be resolved by trial. But motion for judgment on the pleadings also seems like a pretty odd mechanism. Contempts get resolved all the time based on representation of counsel or after an evidentiary hearing or some sort of a mini trial. We see judgment on the pleadings more in the nature of 30A proceedings. So why did you use that process?
Well, it actually seemed like the only mechanism because there had been no discovery. You know, judgment on the pleadings is just short of a Rule 56 motion. It's just the only difference is there's more to the evidence that gets considered. And, you know, Judge Davis could have converted this to a Rule 56 motion, but there was no need because, again, the only distinction between the procedural posture of a motion for judgment on the pleadings and a summary judgment motion is what is the record that results in the undisputed facts that determine the case as a matter of law. And so, you know, I don't, as odd as my brother wants to frame it, it's not really that strange. I had to ask myself the question, well, what would this be other than if it's a Rule 56 motion, but all I have is the pleadings. So then it's a motion for judgment on the pleadings. One last comment I'll make with my brief time remaining.
Certainly.
I think it is important here for the court to look at the two SJC cases, Coyne and Demoulas discussing the contempt, the posture of a contempt proceeding. In particular, the meaning of the order that's being interpreted. What they talk about in both cases is if there's a measure of judicial discretion needed, even that's okay. You know, and COIN in particular involves the use of any and a series of descriptions of potential customers. I think our order is even broader and clearer. So,
Thank you. I'll
thank
have to leave it at that. Gentlemen, thank you both. The matter is under advisement. Harry, what's the times on this one, right?
Yes, first person 15, and then it's 9:33.
Our final case of today's sitting is Richard J. Armato versus Thomas Busey and others, docket 21P0095. As you approach, because I know some of you weren't here when I made the announcement earlier, you are welcome to remove your mask during oral argument, but by so doing, you are certifying that you are vaccinated. All of the judges have reported that we are fully vaccinated and are not wearing our masks just for purposes of today's proceeding. I know one side there's 3 attorneys, so hopefully we can have enough chairs, and then what I'll do, I do have the time breakdown. But what we are doing in between speakers is my court officers are cleaning out of an abundance of caution, so we'll take very, very quick little breaks. We won't leave the bench, but to allow the podium to be cleaned. So with that, I believe, Mr. Bailey, you come to us via Boston today.
That is correct, Your Honor.
And you made great time, so we appreciate that. When you're ready, you may proceed.
Thank you, Your Honor. I do owe a debt of gratitude to a cab driver. But please the court, my name is Greg Bailey, representing the appellant Richard Armato. Rather than get into too many details right at the outset, I do believe that some of the activities that we believe support our claims and the facts will come up as we argue the law. I do believe it makes sense to start with the whistleblower claim. We believe that there was a retaliatory action in response to a whistleblower activity in particular.
I guess as a preliminary question, I would ask you, as to all of your claims, and I'm probably minimizing what I'm going to hear from your brother and sister counsel, but at the end of the day, I read their briefs to say, we were privatizing this golf course, it's been in the works for a couple of years, these things may or may not have happened, but at the end of the day, it's not a whistleblower case, it's not a retaliation case, because we were going to privatize this golf course anyway. Can you respond to that?
Sure. I believe that there are 2 important factors to consider. The first is that we argue that this is a constructive discharge, that Mr. Armato simply was so uncomfortable in his job because of the environment that was created, that he simply was so uncomfortable that any reasonable person in his shoes would leave. We have not argued that the privatization was retaliatory action against Mr. Armato. That is. But
I think your opposing counsel is arguing that almost as a defense. So how does that fact, which I don't think you've disputed, that there was discussions of privatizing this golf course, how does that play into your claims under the whistleblower statute and tortious conspiracies?
Absolutely, because under both claims, Mr. Armato, appellant Armato, was entitled to continue his employment with the town of Salem. He had a pension with them. He was a member of the union. He had an absolute right to move into another position. The problem, as Mr. Armato saw it in that April of 2016 timeframe, is he had just gone through a 2-year period where his life had essentially been turned upside down. He had to work in an environment that he considered antagonistic and hostile. And in particular, a third part.
Let's talk about that.
Yes.
The moderator comes and yells at him on the golf course on one occasion.
Correct.
There's the Uniform Golf Subcommittee asking for receipts on one occasion. I couldn't find that in the summary judgment record. Where is that?
We did not argue that necessarily at this particular level, but in the months after, it is discussed by Mr. Armato at his deposition. In the months after, his protected activity,
Where, because I couldn't find it, though it's long, so I could have missed it. I mean, if you don't.
I don't have it. I could endeavor to find it immediately after the hearing, Your Honor.
So we've got the Yonge the golf course, we've got the request for pro shop receipts. What else do we have that happened at the workplace that supports a hostile work environment?
Change in positions and responsibilities. In particular, they interfered with a long-standing compensatory time arrangement that he had with the town of Stoneham. And it's important to realize that the justifications given don't match up with what actually happened.
The change in position, is that the privatization or is that something else?
He would have changed positions if he remained at Stoneham, but no, during the time before the privatization, he was no longer allowed to use a compensatory time scheme, but they also would not allow him to water the grass. There were complaints about how he would go about watering the grass, who would be responsible for it. So all of these supervisory decisions that he had been making before, after the whistleblower activity, the town got involved and began to take away his sort of supervisory role over the golf courses. So we talk about things that happened on the job as well. Appellee Means and Appellee Busey began to send acquaintances and friends of theirs to the golf course simply to lodge complaints. They began to photograph Mr. Armato at the golf course.
Now, I got that happening once. Is there more than that? Steve took pictures of Armato on one occasion. Is there more?
I don't know how many pictures were taken. Dennis Visconti in particular.
More occasions of it? I mean, I'm not saying one picture.
Oh, no, there were multiple pictures taken of him, as I understood it, on different.
There are multiple occasions of someone taking a picture.
That's what I understand from the record, yes. And multiple occasions of people being sent to develop complaints. And when I talked about...
It's not just Dennis Visconti, someone else was sent to make complaints?
There was another person that went with Mr. Visconti.
But one incident?
I believe there were multiple incidents.
That's what I'm asking. Just Dennis Visconti and someone else
yes.
at that time, or are there...
Different times.
Different times, different people come down?
Different times.
Who else came down?
I don't have that information. I don't believe it's in the record. I believe it was simply from Mr. Armato's deposition testimony.
So I want to understand that the one point you were making, you know, he doesn't take early retirement until after the golf course the privatization decision is made, and he has opportunities to go to other jobs within town. But you're saying that the constructive discharge was from those jobs, essentially, because it was such a bad environment that he wouldn't take that he would not take those jobs.
Correct. He was such an environment. He saw no reason why it was going to stop. He didn't believe that the harassment was connected in any way to his work at the golf course. It was going to continue. And it's important to note that a third party, Mr. Bob Sweeney, who was a Board of Selectmen at the beginning of this, a town resident, and observed what had happened, testified that he didn't believe that the harassment would have ended either. He thought that Armato's decision in that regard was correct. And Mr. Armato, if he were to move into these other positions, was going to lose seniority, was going to lose responsibilities. He was going to be... have less supervisory powers, and he was not going to be able to insulate himself from what he considered this course of conduct that was all geared towards trying to get him either fired or in some way to compromise his pension. He was, at the end of the day, he was most concerned that if he moved into these new positions and was terminated, he would lose his pension.
I read the last 15 years of hostile work environment cases, and except for ones that involve the use of the N-word, they all involve daily harassment, daily sexual assault, daily, belittling. What's your best case that this sort of episodic, occasional scenario you've put in can rise to a hostile work environment?
Okay, again, the hostile work environment, I want to just make sure it's understood. I wasn't using that necessarily as a term of art. I was using it as, in the same way that the Oberg versus City of Taunton case described it. And that was just them describing that you can't go through this insidious pattern of acts. I don't know that this would rise to a hostile work environment. We consider the discussion and the framework put in place in this court's Gustafson decision, which is a Rule 128 decision that we attached.
All right, now you've lost me. It doesn't rise to a hostile work environment?
A hostile work environment is one way to phrase it, but I don't think that that is necessarily the standard that we have to reach. The standard that we have to reach under the Gustafson case and some other progeny for constructive discharge, including the G.T. Stewart products case, is that it has to be so uncomfortable, or that there has to be some sort of antagonizing continuous pattern of conduct. And we think the Gustafson decision is instructive here, because it goes through an analysis of what a jury should consider in trying to determine if a workplace had become so uncomfortable that a reasonable person in the plaintiff's shoes would leave. And it doesn't rise, in that framework, the Gustafson language doesn't suggest that it has to rise to a hostile work environment such as you're describing. But the hostile work environment phrase in our paper simply comes from the Oberg decision. We simply included their discussion of the fact that the Whistleblower Act as a policy was meant to avoid these ongoing patterns of antagonistic conduct with no clear endpoint, but it creates such a horrible environment that somebody has to resign or quit.
So we'd have to find that under the Whistleblower Act, without a hostile work environment or a discharge, you can prove retaliation.
A constructive discharge, correct. And then the next step in that regard, we consider that a constructive discharge would indeed be sort of a negative employment event that would be a prima facie case of retaliation. The town obviously would argue that there are non-discriminatory or non-retaliatory reasons for everything they did in those 2 years. And then it becomes our burden to explain why that is pretext. And in particular, the Armato case versus the City of Medford, the District of Massachusetts case, it sets out some factors of what you can consider, and there's a proximal temporal proximity argument. But when it begins, when the conduct begins shortly after the protected activity, if it is then ongoing, that temporal proximity goes with it, and there can be an inference for all later activities that they relate back. You also look...
I know we could talk for 40 minutes probably, but I don't think we're going to. So I hate to cut you short, but we really do talk about the intentional interference, and I really need you to go person by person and tell me what's on each person, starting with Chairman Busey.
Okay. For Mr. Busey, again, it all starts with the statement by Mr. Ragucci referring to all the Board of Selectmen that you're in a war zone and they're all out to get you. So there was this spark of animus at the very beginning of this whole process. Robert Sweeney, the third-party witness, testified that the selectmen had taken it upon themselves to really create this tension surrounding Mr. Armato's employment. He felt that they were being treated unfairly. So for Mr. Busey in particular, we look at what animus or malice. Number one, it's clear that he was allied with Mr. Means, and he was upset about this reporting activity regarding Mr. Means. And we believe that the animus is also supported by his gratuitous and unnecessary public statements that cast Mr. Armato in a negative light to the entire town. And it was a statement that he made.
That was at the selectmen meeting?
Yes, and it was a completely unsupported allegation. He admitted he had no basis for it. With respect to Mr. Means, I think the animus is shown most easily from him.
I mean, Means is...
Oh, I'm sorry. Go ahead.
That's fair enough. I did have to do each of them, but I'd really like you to do the other selectmen, O'Neill and Collier.
Sure thing. The record is thinner on each of them. The question to them really is the spark of animus at the beginning that you're in a war zone and they're out to get you enough to show animus on their part. We believe that it is. We believe a jury should look at the full context of what happened over those years. In particular, Colarusso, excuse me, I don't mean to be disrespectful, Appellee Colarusso made a statement that suggested that there was some motive here by telling Appellee Armato that he needed to be prepared to lose his job, not to move into a different position.
But she said him at the supermarket?
Yes, a supermarket or perhaps a Dunkin' Donuts interaction. Now, with respect to Ms. O'Neill, and she was, Appellee Colarusso was also involved in what we consider to be a disingenuous argument about the compensatory time scheme. For Ms. O'Neill, again, the record is thinner on her. And again, it's what is that spark of animus at the beginning? We believe that because she knew about means and was allied with means, that is the spark of animus at the beginning. And that she indeed was involved in trying to, and she never even gave a reason. She just simply took the position that Armato needed to be sent to the DPW alone and off the golf course. And again, Mr. Sweeney provided testimony that she in particular was very interested about creating this tension around Mr. Armato's employment. And then finally, with respect to Mr. Ragucci, I think that in terms of showing the animus, his is more improper motive and means. He was the one who was charged with supervising Mr. Armato, and he is the one that implemented the compensatory time. He is the one that took away supervisory powers. He's the one that rejected requests for additional manpower to keep the golf courses running. So again, we see for Mr. Ragucci, it's more difficult to attach him to that spark at the beginning, that sort of spark of animus at the beginning. But we do think that there are several activities that created a negative environment that Mr. Ragucci was involved with. And then obviously for the civil conspiracy claims, we simply believe that to the extent any one of these individuals took any substantial action in furtherance of the common scheme, that they would be liable.
Just let me make sure the panel is all set. Excellent. Thank you very much, counsel. We'll take the rest of your arguments on your brief.
Thank you.
And as we clean the podium, let me make sure I understand in the following order. Mr. Sims, 9 minutes. Mr. Maravelis, 3 minutes. Ms. Brody, 3 minutes. Is that the order also?
That's correct, Your Honor.
Okay.
Yes, Your Honor.
All right. Mr. Sims, when you're ready.
Good afternoon, and may it please the court. I think I'll take my cue from the questions from the panel. Justice Blake, you started by asking plaintiff's counsel to respond to the question that this is not really a whistleblower claim because many of the activities that resulted in the final act, the privatization of the golf course, started years before the Cooking the Books memorandum. Plaintiff's counsel responded by saying, well, it's really a notion of constructive discharge. All of the underlying acts culminate in the privatization, and that was sort of the proverbial straw. So a few points in response. First of all, the Whistleblower Act has an exclusivity provision. Now, I was faulted in my papers for saying that constructive discharge is not a standalone legal theory, and I looked at the case. I don't remember the specific case, but the one the plaintiff cited was either this court or the SJC said, no, it's a subsection or a subsect of a wrongful discharge claim. Back to the exclusivity provision in the Whistleblower Act. It's very clear. Having invoked the Whistleblower Act, which among other things provides for treble damages and attorney's fees against the Commonwealth and its municipalities, something exceedingly rare in my history, is many years of defending state officials and municipal officials. When you invoke the Whistleblower Act, at least as against the town of Stoneham, you've waived. That's it. You can't recast the claim and say, no, this is really one of wrongful discharge. It's been waived by the exclusivity provision of the Whistleblower Act, which I think is 185F.
don't understand why this matters. He's saying that you retaliated against him for whistleblower reasons by constructively discharging.
Yeah, I understand that, Your Honor, but the notion that this is somehow morphed into a constructive discharge claim and not really a whistleblower claim.
But he's saying it is a whistleblower constructive discharge claim. That is the brother's theory.
Then I turn back to what really was the question from Justice Blake. And as the Superior Court found, Mr. Armato is unhappy with a number of, Your Honor said, I think episodic, occasional intrusions over 2 years. He did his job without incident. From the July 14 cooking the books memo, as Your Honor pointed out, there were a handful of instances involving mostly Larry Means for the remainder of that entire season, which goes till Christmas of 2014. His contract is renewed. Where is the animus there? His contract is renewed by the same people he's suing, and he serves for a second year, from the spring of 2015 all the way to his resignation in 2016. So what the Superior Court found is Mr. Armato has failed to show that, I think the court used the word, he's cobbled together a number of fairly discrete incidents, most of which are funding decisions which the Board of Selectmen has every right to make and are not actionable. And when his job was eliminated by the privatization of the golf course, approved at town meeting, aha, I now have to resign because the two positions that Dave Rigucci has at least supported, if not found, they're not comparable positions. I think it's not too much of a stretch, it's not too much of a surmise to say, if the golf course had never been privatized, Mr. Armato would be where he was 5 years ago.
So if there's no cook the books issue and the town votes to privatize the golf course, what were the options available to Mr. Armato for work?
The other two positions?
Yes.
I believe one was at DPW, one was at the town ice rink.
And did the golf course position ever fall under the DPW?
That's a nettlesome sort of question. The golf course was sort of this unique hybrid entity, my understanding.
Because he's sort of arguing I was going to lose seniority, I was basically starting over at the DPW, and that I didn't want to do. So where does the golf course fit in?
I think the golf course was sort of sui generis. It was unique unto itself because of the contractual arrangement it had with the predecessor of the entity that took it over before it was privatized. The books and records, if you will, the financial records, the sales of goods at the pro shop, the giving of golf lessons and things were maintained by Carl Macchio, the golf pro. The maintenance component was done by Mr. Armato and his staff. And, along those lines, in terms of any further lack of animus,
and the problem we have, of course, is that governments, local governments, when I was in local government, aren't black boxes. You've got a group of Busey and Means and whoever else is affiliated with him who are furious about this memo. And then you've got people, other selectmen who, have no problem with this. But why, just because certain parts of the town support him, why can't other parts of the town government make his work environment intolerable?
in theory, that could happen, Your Honor. I don't doubt it could in theory, but I think in the circumstances here, the number of things that have been outlined by Mr. Armato, which occurred, I'll use the court's word again, episodically over a nearly 2-year period, nowhere near approach the level set by the SJC and GTE versus Stewart.
You're saying it's not enough, not that it couldn't. You don't have a theoretical problem. You're just saying it's just not enough evidence. That's
correct, Your Honor. And I think that's what the Superior Court found on the intentional interference claim in particular. There were things that mentioned just now during the argument that there was a change in his position. His position didn't change. The issue of comp time, the very testimony that the plaintiff cites in his brief that Calaruso had a real issue with Mr. Armato's use of comp time is just the opposite. The very testimony cited says she ran. These are elected officials. She ran, and one of her platforms was the town needs to do something with lessening, if not eliminating, comp time town-wide. This is an unfunded liability to the town of Stoneham. The town of Stoneham is not the U.S. Treasury. It can't print money whenever it wants. It has to pay its bills as it goes along. This was a point John DePinto, who's a certified public accountant, made when he came on the board in 1999. Okay, the center won't hold. We have to do something about these unfunded liabilities. So with respect to Caroline Calaruso, that was the one thing that was just mentioned. Anne Marie O'Neill, on one occasion, went to the golf course to have a look, to see how things were going on. Now, maybe that made Mr. Armato uncomfortable. Again, these are elected officials, the highest elected officials in the town of Stoneham. They don't need permission to go to the golf course, to the skating rink, to the library, to see how things are going on. That is not actionable under a constructive discharge theory, under an intentional interference theory, and certainly not as a whistleblower cause of action. I see my time is very much coming to a draw.
Just one, for my clarification, your clients, the only count that they're on is the whistleblower count, right? They're not in the, or are they in the other?
They are named in all of the counts.
Yeah.
Only the town, my understanding is under the whistleblower law, only the town of Stoneham as the employer faces potential liability.
You said in your brief that the selectmen weren't sued in their personal capacity. I mean, the complaint doesn't say either way. Do you have any case law that says if you don't specify personal capacity, it's automatically official?
I don't, Your Honor. I believe the case law from the SJC is you look to the course of conduct of the people, the officials named. But certainly to the extent named in their official capacity, then they can't be held liable under the whistleblower claim because they'd be acting on behalf of the town. I would respectfully ask the court to affirm the decision of the court below.
Thank you. Mm-hmm. Good afternoon, Mr. Marvellis.
Good afternoon. May it please the court. I represent the appellee David Gucci, and as I sort of jumping into it, there are two counts against Mr. Gucci: tortious interference and civil conspiracy. And as Judge Ditkoff noted and asked Mr. Armato's counsel, what did Mr. Gucci do wrong? And the two responses that he received was, well, he understaffed the golf course, and he had part-time workers tend to the golf course in lieu of awarding comp time. That is it, and there is nothing more against Mr. Gucci. The standard for tortious interference is you need to show some type of actual malice. The record is woefully insufficient on that issue, and he was appropriately granted summary judgment at the trial court level. And I submit to the court there's nothing new that changes that position. With respect to the civil conspiracy, it necessarily follows since you don't have a valid tortious interference claim, you can't have a civil conspiracy claim.
Mr. Gucci who tells the plaintiff that they're out to get it.
Yes, it's Mr. Gucci who's the town administrator, who actually has a friendly relationship with Mr. Armato. And actually, we've cited on page 29 of our brief, Mr. Armato's testimony. We asked Mr. Armato, after he reported, the July 2014 booking the books thing, did Gucci change in the way he was dealing with you? No. Fair to say Dave still treated you in a friendly manner, correct? Yeah. Did he treat you any differently after you reported or you drafted this affidavit and reported it to the town. Dave, no. Dave never treated you any differently, no.
Am I correctly understanding that the three selectmen defendants, were the majority of the board that fired your client in 2016? Is that?
I'm not positive. I believe that to be the case, Your Honor, but I can tell you he was ultimately not renewed.
Not renewed, yes.
Yeah. If I can answer any other questions for the court.
I don't see any. We certainly will take the rest of your argument on your brief. Thank you so much.
Thank you, Your Honor.
Last but not least, Attorney Brody. Thank you, Ron. Good afternoon.
Good afternoon. May it please the court. My name is Erica Brody, and we represent Larry Means in this case. Just jumping in to the intentional interference claim. The second element is that the defendant had to have knowingly induced a break in the employment relationship. The court below found rightly that the break was a privatization of the golf course. Larry Means had nothing to do with the privatization of the golf course.
But there's at least two cases from our court that say that you can have a constructive discharge theory for a tortious interference.
Okay, so the plaintiff appears to argue in his reply brief on pages 16 and 17 some of the other things that he alleges that Larry Means did that caused his ultimate, quote-unquote, constructive discharge. And none of those things are actionable. I mean, he approaches him in the supermarket and says, that's what you get when you're with
Sweeney,
right? A lot of actors. Okay. The other things that he appears to identify include the comp time, which Larry Means had.
Yells at him at the golf course, place of work, yells at him at the Stop and Shop.
Right. So the argument would be that caused or induced a break in the employment relationship, and that was done with improper motive or means. But mere hostility is not enough. And I would argue that that's all that this was, mere hostility. Larry Means, there is no record evidence that Larry Means has any control over the budget in any way, shape, or form. It's just simply not there, and he didn't. He was a town moderator. In the privatization of the golf course, as Justice Blake noted, had been, mulled around for years and years and years, 20 years prior to.
He certainly has control over whether he makes Armato's working environment hostile by going and yelling at him.
But that isn't sufficient, I would argue. That is mere hostility.
That's not sufficient because it's not enough motive, or not sufficient because it's not enough to create a constructive discharge?
It's not enough. He's only, the plaintiff only alleges that Larry Means was intentionally interfering with his employment relationship, not that he was part of any whistleblower, nor can he, because he can only sue the town for that. So when you look at the second element, did he knowingly induce a break? I would argue no, because the break is the privatization of the golf course. And secondly, was it done with improper motive or means? And again, I would argue no, because that's mere hostility, and that's not enough.
I see your time has expired. We will take the rest of your arguments on your brief. That concludes our special sitting in Essex County today. On behalf of the panel, I would like to thank everyone in Essex that made this possible. In particular, Clerk Disco, Assistant Clerk Carla Patton, who I see has joined us, Assistant Clerk Jose Mejia, Tamiko, thank you so much for staying with us today. To the staff of the Appeals Court, in particular the Clerk's Office and our IT department, we couldn't have done it without you, so thank you, and we will stand in recess.
Photo on right, please.
Jose.